my grandmother would always say, God gave you senses, you got to use them. And the fact that I was at the parking garage this morning and I turn off, the engine, I get out of the vehicle. And before I even get to the elevator at the parking garage, it's already too hot for me.
Do you know who Marcus Kirkwood is? He's a civil lawyer.
Oh, no, it's Marquise Kirkwood.
Kirkwood.
Yes, I do.
I just got an email from him and I know it's got to be spam because I haven't talked to him in a long time.
Yeah, you should call him.
Yeah, he probably got hacked. His email.
Huh? All right, everyone, I'm going to call the docket. Pete Ortega, Norma Oliva, Samson is custody, Belzon custody, Randy Gallegos, Casey Ming custody, and they'll bring your client out. Yes.
On this meeting, when making this, we wanted to maybe approach rural information, brainstorm what we can do for her. There's some issues that we're doing as far as mental issues go.
All right.
And people thought you might have some good insight. So.
Okay. Now the pressure is on.
One second. Come here. Everyone should clap when Julia comes back in.
Yeah. Oh yeah, I'm telling you. Hello, are you here to morning? How's it going? Good. Yay. But yeah, I was the only person who was worried about you. I'm like, did he make it for the parking garage? Yeah. All right, so we're gonna take 5.
the transportation operations, we're not in trouble.
Well, so it's just that much, 'cause she doesn't put us up.
Well, she's hearing, I think, some other inmates that that's available. I looked on my cross point, for example, the work that's available for the. Check to see if it's anything good for now, they could have put the same. I don't know if you think that would have been.
Hello,
Hello,
how are you doing today?
doing all ready to go.
Okay, well, this is what we're gonna do, okay? Because one, I don't want to send you out into the world where you won't be successful, okay? So what we're gonna do is, felony drug court said they're willing to speak with you and counsel. When they interview her, if you could be present, because I think you have more of a relationship with her where you can make sure that they're asking the questions in such a way that it's easier for her.
Mhm.
So we're gonna do a referral today. They will be able to see you because it's Wednesday. Vashawn, can you maybe see if they are willing to see her maybe this week if possible?
This week I could do Friday, Judge, I would not be able to do tomorrow.
Okay, all right, so see if they're maybe able to see her Friday. And actually, the person that I was able to speak to, that's the person who attempted to do an interview with her before. So they sort of have the basics. So we're gonna try to get that done this week and we'll bring her back next week. And so hopefully we'll have everything in place for you, okay?
So where will I be going?
Well, felony drug court, and they will help you with housing. They will help you,
I can go back to Haven.
well, see, Haven for Hope is great, but I want to make sure that you have the resources that you need. With felony drug court, they will actually have case managers and someone to work with you on a daily basis, okay?
What about the Sound Ministries or Cost Point?
Well, I will tell you, felony drug court has access to those programs as well. So it's best that a professional see what program is best for you, okay? Because I don't want to set you up for failure.
Okay,
All right. And then my understanding from speaking with your attorney and speaking with the state, if you're accepted in the felony drug court, then the motion to revoke will be taken care of to your benefit, okay?
okay, so I'll be able to go home next week?
You're going to be transferred to felony drug court, and felony drug court will make those decisions, okay?
Okay,
All right. So what I'm going to do is I'm going to sign the referral for you to be interviewed, and counsel, Ms. Abrams will let them know that you're available on Friday.
So Judge, I just, they aren't able to do it on Friday because they do have to work on Friday,
Mhm.
but they are able to do it first thing on that.
Okay.
If not, I'll make it work.
Okay. All right. So they're going to interview you on Monday.
Would that be here, Judge, in your word?
No, their offices, are near the Bear County Jail.
Okay,
I'll give you the address.
okay.
Okay. And so what we'll do is they're going to see you on Monday, and council will recall it for Tuesday.
Okay.
I'll put her on the docket for Tuesday. But if you already have the information on Monday, we can take care of it on Monday.
Okay.
Okay?
so I'll be able to go home if he decides for me to go home Monday.
Well, Monday, you're going to have an interview with the people at felony drug court. And if they accept you, which I think they probably will, then we'll probably be able to resolve your matter here on Monday afternoon, council, or you can just call Megan and let her know what the outcome is.
Yeah.
But I want to put you on the docket for Tuesday to make sure that you're not lost in the system. But your case will probably be resolved by Monday.
We'll have more answers on Monday or Tuesday and should know what's gonna happen and where you're gonna go.
Okay, so I'll be able to go home.
Maybe you'll be able to go, hopefully somewhere in about 4 or 5 days, we'll know where. We have a
So
better
I'll
idea.
be able to go home next week.
Well, right now, I don't know about home, but we'll have a place for you to stay. You mainly want a place where you can go to stay, right? Whether
Yeah.
Sands Ministries, Haven for Hope, Cross Point, you want a place where you can go, right? A place
Yeah.
of your own. That's what we're trying to work on. Okay? We should have some answers next week,
So I'll be able to go home as soon as I find out the answer next week.
possibly.
Okay,
Okay?
okay.
All right, so I've already signed the referral for them to interview you. And council, Norma put this back on July 14th.
Yep.
And so, as I said before, we'll probably be able to take care of this by Monday, okay?
So when will I be able to go home?
You know what? Felony drug court will make that decision. So this is what I want you to do when you're interviewed by felony drug court. You can ask them that question and they'll be able to tell you, okay?
Okay,
All right, thank you so much.
okay.
Answer that question, Judge.
Sure, just one second. Yes, just give me one moment. Let me put this in the system. That's why you're not quick. I just. Yes.
I decided
I
to
had
go
a
that route.
where the men had immigration issues
Mhm.
and you appointed Ms. Coles to the to do the immigration stuff.
Yes.
So she's been having trouble getting paid because they're telling her, you're not the attorney of
Oh,
record.
they said they didn't.
So
Yeah, she's an expert. Okay.
so I just wanted to file that stuff so
Okay.
she'll get paid.
Okay, all right.
Oh, yes.
And then the other one that's already in here, she just needs to like apply for it the next time. Because the next time she comes, it's her like final with it. So I.
Yes, you can tell that.
Yeah, and if you can let other attorneys know whoever, to me, they should see that she's, I always tell them to file it as expert witness or whatever.
Yeah, I think she had her clerk just submit a regular traditional
Mhm.
felony voucher and they're like, we don't see your name on there. So it's like, I'll do this and they'll probably pay her. just
All right,
fine.
thank you. You're welcome. Hi, Mark. Son. Cindy, we're gonna go on the record. Court is gonna call 2026 CR 005972. State versus Danza Senson. Are you Danza Senson? All right, so you've had an opportunity to speak with managed assigned counsel. And counsel, what were the results?
At this time, he would like to have a different attorney appointed. And he has posted bond yesterday after court. So he should be released in the next couple days.
All right, all right. You're asking for a new attorney to be appointed to represent you?
Yes, ma'am.
All right, so just have a seat. We're gonna see if we can get an attorney to come in, all right?
Appreciate that.
You're welcome. All right, and then Mr. Belzon. Sorry, just one moment. All right, so Mr. Belzon,
Yes, how you doing, Judge?
hello, how's it going?
It's all right.
Yeah.
I just wanted to let you know, hey, I respect, you know, what I'm saying, I've been hearing a lot of good things that you're trying to help a lot of people and you got respect for me for that. I just appreciate what you're trying to do, you know what I'm saying? Trying to help people instead of just,
Oh, hey, I try to do what is right.
and then, My bad. One more thing is you had reset it for trial. I'm really not trying to take it to trial, you know, I got top of the handed.
No. So here's the thing.
My bad, you know, what I'm saying? But I'm just saying, you know, all right, cool. Yeah,
All right, so here's the thing. I am legally not allowed to talk to you whatever agreement or something you've worked out with the state. What I can tell you is your attorney is not going to be here today. This is a possession less than a gram case. So one, you can wait for your attorney. I don't know when he will be back.
Monday.
So he'll be back on Monday, or if you are asking for another attorney to be appointed to you, an attorney can be appointed to you, and we can take care of your matter today if that's the agreement you've had with the state.
Oh, no, he was just trying to reset it, and then you had said reset the trial, and I was like, yeah, but yeah, no, he's good. Yes, man.
All right, Norma, we're gonna recall Mr. Belzon.
Yeah.
For Monday. All right, is there anything else?
Oh, man.
All right, we'll see you back on the 13th.
All right, thank you.
Thank you.
I think that was all correct.
Yeah,
Okay.
thank you. You're so
All right.
awesome. Norma,
Yes,
did you give Mr. Sampson his reset form?
sure did.
All right, thank you. All right, and where is Norma Oliva?
Valentina was just here, she did say that Miss Oliva sent her a text, she was running late, and then Valentina just stepped out to another court. She will.
Okay.
Judge, he's been sitting like this everywhere now.
Oh, my baby, he's so
He
cute.
just squats on his knees. And he's gonna walk any minute, but that's the position he's always in.
Oh,
Squatted over on his knees.
he's such a cutie pie. All right, so it says Bear County to pay $3.7 million to nearby counties to house inmates in other jails.
But the other one, but his hair is always so long, it just look like him fun too. It's just his little boy bun.
And Spurs get approved to play outside San Antonio for specific games.
Oh, really? Even more?
I think they requested an extra game or something. Well, if they're playing in Paris, I will go there. Oh, well, I'm gonna have to go to Paris just to go. Oh, yes. Vashawn,
Yes.
guess what's happening in January? I don't know how the weather is gonna be, but the Spurs will be playing the New Orleans Pelicans, which really historically should have been the New Orleans Jazz. But
Yeah.
they're playing, yeah, but they're playing them in Paris, France. So it sounds like that's where I need to be. Oh, I could do, and then they're playing in Manchester, England. I will tell you, I went to England. England is so expensive.
There's this talk in the commission's report about the overcrowding. And especially in Germany. It's been delayed.
Oh, yes. I think so too. Mhm. Oh, wow. You know, I went with a group of friends to England
Mhm,
and I never liked pizza,
mhm.
but
Because what are they?
that was the most expensive thing. I'm like clipping coupons. You know, usually when I go to a hotel, I never look at the coupons. I'm like, eh. But they had a coupon 50% off pizza. I stayed in London for 2 days. And if I would have been spending the way I normally spent, it would have been, I would have had to spend $1,000 a day. That's how expensive it is. I started to say, let me stay at the tower. Mhm.
$44. And I'm like,
But I love Bath.
Yeah. I know right now it's at the beginning and.
Well, we went to Bath and they were telling us, oh, Johnny Depp has a place here, right? So of course, everybody's trying to do their Johnny Depp sighting. But when we go to Bath, they have the pool or whatever. And they're telling you, oh, people would come here. I don't know if they call it Bath because people would come there and bathe. I have no idea. But they were telling people, do not touch the water. Do not get in the water, you know, because it's germs, right? So of course, me, being the person that I am, trying to protect the community, being like the commercial, the progressive commercial, turning in my parents. They were saying, don't put your hands in the water. So we go there. And when I look at the water, I'm like, who in their right mind would want to put their hands in this water? Oh, it's like pea soup green, right? And at least there wasn't this heavy smell coming from it. No, no heavy smell. So guess what ends up happening? What ends up happening is I see people with children letting them touch the water. Like, people, did y'all just not hear? They have signs that say, yeah. I'm like, what is next? Yes. I'm like, what's next? Drinking the water?
That's just not get in the life of river, because I get sick every single time. It doesn't matter. If I just get in for 10 minutes, I'm sick. I think there's a point where we actually just go to. My cousin lives in Blanton, her husband worked for the Park Service for 30 years, so.
He played the fountain role.
Yes.
And that's that was originally through Southern Jenny this state.
It's
She worked there for a long time. She worked there for a long time. So we don't keep her.
Yeah.
Now he's trying to take her from sleep. He trying to take her from sleep. He started and yeah, she didn't want to go to that. Just started taking. She's having a mental health crisis. He said, oh my gosh. She's not, she's freaking out. I need to get her.
Well, things take time.
So he, in his mind, is like, I gotta get my friend home. They, in their mind, are like, we need to stop this guy hurting our coworker, our former coworker who we know.
Oh, Bill's and Wesley's.
Everyone is trying to do the right thing.
Everybody's the day, so.
Exactly.
Orders, poultry.
They think.
And we lived overseas, we're trying to, like the British toilets, just like two spots for you and.
Oh, there's right on the outside of the mission. They have, they have, pork chops. For 24. Special going on.
Yeah. and why would I go up on here for you guys watching that? Yeah.
Other than to a certain.
So
point, to a certain
definitely.
course, you got force now.
All right, Randy Gallegos.
Council president, he's talking to his family about what he wants to do.
All right, Norma, if you could have a jury called up, please.
So I mean, that's gonna be our argument.
For right now?
I think,
10:30.
well, I can not get eviction, but. Thanks. Fortunately, because the condition is we're in a situation when you zoom out. When you're zoomed in from the bars or standpoint, they think they're protecting you. That's a girl, this weird guy's hitting. But when you actually zoom out. He didn't show up and like, hey, what's your name? Let me buy you a drink.
That is correct.
Somebody, before they go up for that, he says,
All right, Ray, what is happening with Mr. Ortega?
Working on a plea, Judge. I'm hoping to have it later. I was just gonna tell Norma I'm gonna step out for a minute, but the state's working on paperwork.
All right. So then, state, it appears we're going on Randy Gallegos. Okay.
This or that.
Has he told y'all if he's going, if his client is found guilty, if he's going to the court or the jury?
Unknown judge, the state offered a new offer. I think they're talking about it with.
Okay.
Okay. One more. Could be higher than return. I just saw this. I got off touch with since. Okay. I wanted to tell you that I had this. Is that yours? Did you leave one before? Did you ask? Did you ask me if we leave one of those before? I know there was one here, that somebody even left, but I don't. Born on that.
We did file a motion to dismiss as well as motion.
Oh, where's your motion to dismiss?
For you, Your Honor.
All right, thank you. Could you all pull the indictment on Randy Gallegos, please?
Yes, Judge, I'm working on that right now. One moment, Judge. What's your name?
Austin Hagee, first name Austin, last name Hagee, H-A-G-E-E.
Turn it.
Oh, no.
I'm just gonna swear him in on the public application.
Okay, sure.
Who is he here?
I think so. All right, State, did you tender the report?
A subpoena sent to TABC yesterday. I was told that they were served this morning, and I'm waiting for that report to be returned.
Okay.
We should have it, as soon as I have it, it will affect the defense. See,
All right. And did you call them and just ask them to email
so I've called both agent and her lieutenant this morning. I called them several times over the last week or two, and I received nothing but voicemails, no contact time. They are in contact with our investigator, Sergeant Miguel, but I have not received any contact personally.
it? All right. Do you want to ask your investigator to, if he has contact with them, to just have them email the report?
That is what he's gonna ask.
Okay, all right, thank you. And how long do y'all expect this trial to last?
Yeah, I think for the state side, I think we'll wrap up.
Okay. All right, Cindy, you ready?
Yes.
You ready? All right, the court is calling 2024 CR 5108 State versus Randy Gallegos. Can I have parties announced?
Ready for the state? Austin Hagen for the defense.
And Hannah Hawkins for the defense as well.
And where is Randy Gallegos? All right, y'all are scheduled for jury trial. The defense has filed a motion to dismiss for failure to comply with Article 39.14. State, have you had a chance to review the defense's motion?
We have, Judge, we have brief argument response.
Yes, what's your response?
Basically, Judge, I've printed out the case that was cited to by the defense motion. That would be State v. Heath, citation 642 Southwest Third 591. I could tender a copy to the court.
Yes.
And I'm also providing a copy to defense. And Judge, in reviewing the defendant's motion, they cite to a failure to comply with Article 39.14 of the Code of Criminal Procedure because pursuant to the Texas Administrative Code, breach of the peace are required to be reported to TBC no later than 24 hours after the incident involving serious bodily injury. Judge, in reading Heath, I don't believe that dismissal of the case outright is the appropriate remedy. Heath, if you go to the tab portion, it states, in other words, even though lesser remedies might suffice to cure harm, the most extreme remedy of exclusion is required only if the record shows the prosecutor intentionally violated the order in a calculated effort to frustrate the defense.
All right, so here's my question. Number one, when were you made aware of the TABC report?
I have to review my notes, Judge, but it would have been about a few weeks ago when I was preparing for trial. I was talking with the complaining witness, and he mentioned for the first time that there was a TABC report that was made to Agent Maggie Centillion.
All right, and so when you learned of this information, what did you do?
I filed a memo disclosure that day, and that memo disclosure was sent to defense. And I also called Agent Centillion on the phone number that Pete Rios provided me with. And I left a voicemail. A few days went by. I left another voicemail. A few more days went by, and I talked to Lieutenant Jeffrey Talley, who is in the Austin office of TABC. I left a voicemail with him saying that we needed this report. After that, I didn't hear much back. And then yesterday, I realized that TABC report had never been brought back to us. So we filed for a subpoena, and they've been served this morning. And being told that they're going to comply with the subpoena.
All right. Anything from the defense?
Yes, Your Honor. In our perspective, I understand that the state
recently spoke to their complainant a few weeks ago and found out about this TABC report, but they've had this case. It allegedly occurred September 2022. It was indicted by the grand jury in 2024. So they've had 2 years since the date of indictment and longer if you consider the period of investigation to obtain this report. The detectives spoke to the complainant, could have found out about the TABC report at that point. The incident occurred at the bar, so that is a line of questioning that should have been pursued at that time, and certainly something that should have been looked into by the state prior to a few weeks ago when they were pre-trialing their complainant. It is within the state's possession as it's within the records of TABC, which is a state agency. So for those reasons, we're asking that the case be dismissed for failure to comply with Article 3914.
All right, motion to dismiss will be denied.
Your Honor, we would ask that any mention of the report or testimony about a report made to TABC be suppressed and not admitted into this trial.
All right, then the court will make a ruling on that once the report is received by the defense.
Yes, Your Honor.
And my understanding is you all will have that report today. And once you all receive the report, you may decide that you do not wish for it to be excluded.
Sure.
All right. So there's a plea on Mr. Ortega. We'll take up that plea first. And then each side, 20 minutes.
Can we have 30, Your Honor?
I'm sorry.
I think we're both requesting 30 minutes, Judge.
All right, sure. 30
Thank you.
minutes. And Norma Oliva?
Norma Stefovich.
No, I'm talking for the defendant. Can you make an announcement outside in the hallway for Norma Olivia? I forgot to pronounce all vowels.
Just give me 2 minutes to prepare this, plea.
All right. And so the charge in this case is aggravated assault causing serious bodily injury.
Yes, Your Honor.
Okay. All right, so both sides, what we'll do is we're just going to do jury selection today. The state should have that 1-page report and you all will have a chance to review it. And then we'll do testimony beginning tomorrow.
Thank you.
You're welcome.
Does the state still have all of its switch rates and stuff?
They're going to need a chance to review whatever report. So, sure. All right, thank you.
Your Honor, we do have a motion in limine. Would you like that to be heard now or after the jury's and?
The motion in limine, what is it in regards to?
Your Honor, I can tender a copy.
Thank you.
My filing got returned this morning, so we're refiling them.
It happens. And I will tell you, when it's done, normally the clerks don't get it and I don't see it. So it's always best if you all just present it to me.
Yeah, are they? You guys. Okay. Yeah, they did.
Thank you.
I thought maybe they didn't want one.
All right, state, would you all wish to view the motion in limine request by the defense?
I reviewed it last night, Judge. I didn't see anything glaring.
No, he would have to fit the more here. We will put him,
Okay. So I'm to find out.
or you can fit it right here, right? Yeah. Start second.
You're gonna be taken out, that's the one.
Man, make sure you get your cell phone this time. We'll be coming in. You're welcome.
All right, and to both parties, is there anything about this charge that I'm not aware of that's not in the indictment that makes this other than a second degree?
Yep.
Well, I mean, I'm only going by the indictment. According to the indictment, it's a second degree. So is there anything that I'm not aware of that would make this something other than a second degree
No
felony?
criminal history or anything else that enhances the honor.
All right, thank you. And he's eligible because he doesn't have anything?
There's no prior felony.
Okay, all right, thank you. That's what I was asking.
Yes.
Yes, Your Honor. Sorry.
Got
We missed the lead.
it.
You can sit by special counsel.
I was gonna move.
Oh. Yes, he's waiting for you after the,
And Norma, if you can find Ms. Kogut.
oh, yes, ma'am.
And do you all have a notepad over there? It seems that the last judge who was here took my notepad.
I think this one's neat.
Awesome, thank you.
Judge is asking for you. We're about to start trial. Okay, thank you. She's in the 226 in front of Judge Robinson's bench.
All right, Pete Ortega. All right, the court is calling 2025 CR 00736 State versus Pete Ortega. Can I have parties announced?
Raymond Martinez from Mr. Ortega.
And are you Mr. Ortega?
Yes, I am.
May he sit, Judge?
Yes.
Go ahead. Mr. Mr. Chairman. Go ahead.
It will, you might want to hold on.
Yeah, great. Sorry.
All right, counsel, have you received all discovery? Did you review with your client?
I have, Your Honor.
All right, in probation, there are no applications. Court will find that the state is in compliance with discovery. There's no indictment. Oh, here we go.
Sorry.
Mr. Ortega, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sure.
Counsel, do you waive the reading?
We do, Judge.
State, are you proceeding on the indictment as presented? Mr. Ortega, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes,
All right, you're charged with possession of a controlled substance penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yeah.
Counsel, has your client been able to provide any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Ortega, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a US citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
The court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, punishment is to be assessed at 7 days in the Bear County Jail under 1244. There are no applications and no fine. Did you understand that to be your plea?
Yes, sir.
Defense and state?
Yes, sir.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor, state offer receipts exhibit 1 and all attachments.
No objection, Your Honor.
Right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge, we'd ask the court to follow the plea agreement. Mr. Ortega admits that he was in possession. It was less than half a gram. He self-medicates. He's got neuropathy in his legs. He's got missing cartilage in his knees, and he's got sciatica. All of that is what explains why he gets around so gingerly. And he's only 62 years old. So he suffers, and he understands that that's not the way to medicate, but sometimes when you're in pain, you do what you got to do. So despite the somewhat leniency of the plea offer, we'd ask the court under the circumstances to follow the agreement.
And sir, who is Miss Yepes to you?
She did this.
Yes.
She's a friend of.
Oh. All right, then this is what the court will do. The court will follow your agreement. The court will sentence you to 7 days in the prison. I'm sorry, not prison,
Yeah, no.
Bear County Jail. Give you credit for any time served, and I'm sentencing you under 1244. And is this a judgment
I
satisfied?
believe that's Judge.
The court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, so sir, I understand, the state of the healthcare system and not being able to afford certain things. But taking illegal substances is not good. And the reason why it's not good is because you never know what you're getting.
Yes.
And anything could end up happening, okay? So you can go to the emergency room, and I know people say, the emergency room is really not primary care, and I know that puts a strain on the system because people are just going in the emergency room instead of taking things up front. But if you don't have health insurance, that's probably the best place for you to go.
Yes, sir.
And I always recommend, I know sometimes people are saying, oh, you need to go to this hospital, this hospital. Public hospitals, like university, they are always up to date on coming technology and new things because the government usually gives them research funds. So you may want to try it, okay? All right, good luck to you, sir. You're welcome. All right, so on this case, have you all had a chance to review the motion in limine?
Yeah, Judge.
All right, and I will tell you, I'm sorry, we're on the record in 2024 CR 5108. The motion in limine, the one where they are requesting that you refer to the complainant as complainant or by their name, that's going to be granted. You're not allowed to refer to them as a victim. And could I see because that's my only copy.
I think the only issues that we're gonna have are with number 6 and number 8.
All right, so. All right, so here's the thing. Number one, y'all just need to approach. Because I don't know extraneous evidence of a crime or anything. I have no idea what this case is about other than what I've read. So state before mentioning any type of extraneous crimes or criminal history or misconduct. If there is any, y'all need to approach and let your witnesses know.
Yes, sir.
With regards to number 2, I mean, hearsay, y'all just need to object to hearsay if somebody's saying something that is attributed to the complaining witness. If it's something related to medical diagnosis, then it will need to be established that it's for medical purposes before it's even allowed into evidence, and y'all need to approach. Let's see. All right, and then, people need to be called as witnesses before the statements are allowed to be introduced. And if someone thinks there is some sort of an exception, then y'all need to approach and I'll hear what either side thinks the exception is. All right, with regards to the defendant being arrested in handcuffs and are in the backseat of the police vehicle, y'all need to approach on that because I guess it really depends on.
And Judge, I don't even think that exists in this case, so we're good there.
Okay. With regards to 911 calls, y'all need to approach on that. I don't know if there's a 911 call. I don't know what's on the 911 call.
That's probably gonna be our first witness tomorrow, Judge.
All right, so we can have a hearing about that once jury selection is completed. The limiting instruction, yes, don't refer to the complaining witness other than the complainant or by their name. The victim impact testimony, just make your objections with regards, because victim impact did not happen during the first phase of any trial.
I don't anticipate it happening here, but we will have to delve into his injuries to prove the SPI part of the offense.
And Your Honor, I understand that the complainant will be discussing injuries that they sustained.
Mhm.
Our issue really relates to any complication that happened after the initial injury was allegedly sustained. In conferring, the state has revealed that there were some complications, but there hasn't been any medical records or any discovery relating to those complications that were provided to the defense. All we were provided was documentation from the emergency room visit the night the incident supposedly occurred. So we believe that anything that came after that would be improper victim impact. We're trying to get a limiting instruction on that since we have no information other than what the prosecution has represented to us that exists.
And if I may respond, Hannah, I think looking in discovery, there are documents from the orthopedic group between a Dr. Ballin and Dr. Burns that go into what you're talking about. And those were on discovery.
Those records were never tendered to us. We only received the university emergency room records. So if there are additional records, those need to be turned over. That's our concern.
All right, so states, you have to make sure that they have received any additional records. And if they have not received those additional records that are related to any complications, then the court will entertain whatever motion the defense wishes the court to entertain. And before going into complications, we can have a hearing outside the presence of the jury, because I don't know if there are complications, and I don't know if those complications are related to the alleged crime in this case, or if it's a complication related to something that's overlooked. I have no idea. So I won't know until I hear evidence. All right, so each side you'll have your 30 minutes. Does anyone want a warning?
Yes, Judge, 5 minutes.
And can I put everything on here to make sure that it works?
Sure.
Not like last time. If I just have the opposite of the Midas touch. Please.
All right, everyone. Attorneys?
Yes, John.
Okay,
Okay, I'm gonna press out.
but before the jury is brought in, the panel is brought in, this is what I want y'all to remember. Number one, do not stand in front of the juror who's speaking because it makes it difficult for Cindy to hear. Please talk one at a time because it's making it difficult for Cindy to take everything down. She can do it, but that's a problem. And I always tell the jurors this, but they never follow my instructions. The people in the box and the people on the first row, they don't have to stand when they speak. However, please encourage everyone else who are not in those rows to stand when they speak because it's difficult for Cindy to hear. All right?
Yes.
And we have a court reporter in training. So don't make her hate this profession before she even starts.
So can I first?
And this is gonna be her first jury selection.
She's gonna love it.
I've already heard great things.
So Deputy Mahia, just give us 2 minutes and then we'll bring them in.
brought some cough drops if you need some, Judge.
Oh, no, I'm good. And I really want you to look into that coughing thing.
It's probably just my job. I always get these rib pains and my doctor told me yesterday when I went, or the day before. It's your job. I said, it's not my job. She said, "No, it's your job and I'm gonna prove it to you." So she's going, that's the way I sit and lean forward and you press your legs and then that's why you get the rib pain. So I'm like, okay.
Does anyone know where she went? Ah, okay.
All the way down. Number 37. You're on the next deck. Number 44, you're on the next bench. Number 51, you're on the next bench. 51, last bench. Number 57, you're on this first bench up here. You're on figure 61, you're on. 65, your next bench. Number. Okay. You're on the next bench.
All right, everyone, please be seated. All right, everyone, good morning. All right, you all should not be asleep at this point in the proceedings. So everyone, good morning. All right, you are in the 187th District Court. You're on the 4th floor. I'm Judge Boyd. What floor are we on? All right. What's the court number? Who's the judge? Now, you're probably saying, we've been standing out in the hallway. Why would she ask us this question? We know where we are. The reason why I always ask jurors that question is because whenever we take a break, nobody is allowed to remain in the courtroom. You all have to go outside. And it never fails that when we take a break, somebody gets lost. They say, I looked up, everybody was gone. Then we have to send deputies to search for people. We've had people going to be selected on other jurors, and we're like, you're in the wrong courtroom. So if you ever get lost, if you remember the 187th District Court, the 187th District Court is the only 187th District Court in the state of Texas, because these courts are given the number of when they originated. So you won't find a 187th District Court in Austin or anywhere else. And then if you remember the 4th floor, you walk up and down the hallways, at some point you will see this court number. Or if you remember the last name Boyd, I'm the only Judge Boyd in these courtrooms. So if you ask any of those questions when you get lost, someone will be able to tell you where you need to be. Now, to my left, I have the court reporter, Cindy. Cindy is taking down everything that everyone says. Right next to me is a court reporter in training. So what do we want to do? We want to make sure that the court reporter who's in training realizes I have chosen a great profession. So how do we make her believe that she's chosen a great profession? We make the job easy. So you all have cards in your hand. We're going to practice raising our cards. I want you to raise your card if you want to make the court reporter's job difficult. So nobody raised their card. So then the question becomes, how can we make her job less difficult or not difficult at all? One, is everyone able to hear me in the back? If you will talk at the tone I'm speaking at and the pace I'm speaking at, her job will be easier. If we all talk one at a time and not talk over each other, because I know sometimes when you start having a conversation with people, you finish their question or you finish your sentence. If we don't do that, that'll make her job easier. Now, I want you to practice raising your card. So all of the jurors in the box, please raise your card. And I will tell you when you can lower them. And everyone, to make my job easier and the attorney's job easier, make sure your numbers are facing us. All right. And then everyone on this front row, if you'll please raise your card. No, I haven't told anybody to lower cards. We got to listen to instructions. Now, for all of you who don't have your card raised, to make Cindy's job easier, I'm going to ask you to stand if you're asking any questions or answering any questions, because then she'll be able to hear. Is everyone able to do that? All right, so everybody can lower your card. Now you will see people who are coming through this door. They're coming through that door because they didn't read the sign that says we're in a jury trial, don't come through this door. The people who come through this door, they're coming through the door to speak to me about issues unrelated to this case. So just ignore them. We have Miss Abrams here. She's assigned to this court and she's working on things unrelated to this case. So just ignore those things. Does everyone understand? All right, with that being said, I'm going to allow the parties to introduce themselves. This is the state of Texas versus Randy Gallegos. So state, if you are introduce yourself.
Good morning, everybody. My name is Brandon Prater, I represent the state of Texas.
My name is Lauren Espinoza. I also represent the state.
Defense.
My name is Austin Hagee. I represent Randy Gallegos.
And my name is Cam Hawkins. I also represent Mr. Gallegos.
All right, and behind you all?
I'm Lucas Olsman. I represent defense.
All right, and then Mr. Gallegos, if you will introduce yourself, please.
Morning, Randy Eagles.
All right, and then we have, sometimes we will have family members of people who are on trial. They will come and sit in. This is a courtroom that must be open to the public, and you are, thank you. So raise your card if you recognize any of those parties that have introduced themselves. All right, number 52 and 55. All right, number 52. Who do you recognize? All right, thank you. Oh, and I'm so sorry. One other question. Which department do you work in? Civil. All right, thank you. Number 55, who do you recognize?
I recognize Mr. Holtzman.
And which church? All right, thank you. So jurors number 52 and 55. You both said that you believe you recognize a party that's involved in this case. Does your recognition of them preclude you from being able to be a fair and impartial juror? Number 52. All right, thank you. Number 55. Thank you. All right, now the next thing I want to talk to you about is the charge in this case. The charge in this case is aggravated assault causing serious bodily injury. The state and the defense, they're going to get a chance to speak to you, but neither the state or the defense can tell you what they think the facts of this case are. The only way you will know what either party thinks are the facts in this case if you are actually selected to be on the jury. So when the state and when the defense asks you questions, they're speaking in hypotheticals. So don't do a Mrs. Kravitz from Bewitched on me and say, oh, those are the facts of the case, because you will not know the facts of the case unless you're on the jury. Now, with regards to criminal cases in the state of Texas and felonies, people are brought to trial or they come through trial by way of an indictment. What is an indictment? An indictment is just a piece of paper. And that piece of paper is really for the person who's being accused of an offense to know what they're being accused of. But it cannot be considered by you as evidence of anything. Does everyone understand? All right, so we're going to practice raising our cards again. Raise your card if you have ever had a ticket. All right, so now I will tell you what follows true. San Antonio has some of the worst drivers. So, all right, lower your cards. All right, raise your card if you have not had a ticket. So I want to apologize to all of you because you are driving for other people and not just yourself. So you can lower your card. So I've had a traffic ticket before. And it was when I was probably like 19. So again, as I tell everybody, here I am 21 and I still reflect on that time. So let's say an officer pulls you over, right? And back in the day when they would pull you over, they would give you a carbon copy. Young people, I know you don't know what carbon copies are maybe, but they would have their ticket book, they would write on it. Now I think they do something electronically or something. But let's say they pull you over and they say that you ran a red light. So when you're given that ticket is to let you know that, hey, you're being accused of running a red light. And usually on the ticket, it will tell you, this is how much we charge, the city charges or the county charges for running a red light. If you want to, you can just send this money or cashier's check or whatever it is to this place. If you want a jury trial, you can show up to court, and usually it's on Frio or one of these other places. So when you accept that ticket from that officer, you're not telling that officer, yeah, you're correct, I did run a red light. You're just accepting that ticket so that you'll have knowledge of what you're being accused of. Because it would be a shame for you if you get that ticket and you say to yourself, you know what? They're saying I ran a red light. I know I didn't. That was a stop sign. And then you show up to municipal court and you're ready to go to trial, and you're sitting there and you're doing your jury selection. And then all of a sudden you find out they're accusing you of running a stop sign. So that's what an indictment is. It's just a piece of paper to give somebody notice. It can't be taken as evidence by you. Does everyone understand? So the question becomes, is anyone going to hold it against Mr. Gallegos because he's here under indictment? Now, the next thing I want to talk to you is certain rights that anyone who's accused has. Number one is the right to remain silent. What does that really mean? That means that you don't have to testify. So the state can't, as a part of their case, say, you know what, we're going to call the person who's accused. The person who has the right to say whether they will testify or not is the person who's accused. I've been a defense attorney. I've been a prosecutor. There are many reasons why somebody may choose not to testify. Sometimes people are just scared of public speaking. I would have some clients, I would talk to them. I said, look, you're sweating and nervous and you're talking to me and I'm your friend. I'm here to fight for you. You would not make a good witness. And then sometimes I would be in a jury trial and I would tell my client, the state didn't even prove their case. There's no reason for you to testify. And it never fails. There's always a juror or a potential juror who says, well, if that were me, I would want to tell my story. And I always chuckle inside because I'm like, it's not you. You don't have an expert telling you what is your best option or what you should do. People tend to look at the legal profession different from any other profession. If somebody were getting heart surgery, you may go to your first doctor and the first doctor's like, hey, you need heart surgery right away. And you're like, I'm getting a second opinion. You go to the second doctor says, yeah, you should have got this heart surgery yesterday. And you're like, I'm gonna go to a third doctor. And the third doctor tells you, you should have got heart surgery 2 days ago. You would never tell that doctor, you know what? I know what you're saying, but I feel like I shouldn't be doing this. Or either I'm going to go forward with the heart surgery, but let me just tell you what scalpel I want you to use and how we're going to do the stitching. So I always tell people that because whether or not somebody's accused, someone accused of a crime decides to testify, that is completely up to them. And you can't hold it against them if they decide not to testify. You can't say, that's a mark against them. They didn't testify. You can't consider it at all. During deliberations, you can't even bring it up. Does everyone understand?
Yes.
Is there anyone here who's going to hold it against Mr. Gallegos if he decides not to testify? Right. Now, the next thing I want to talk to you is about the presumption of innocence. Everybody who is charged with a criminal offense is presumed to be innocent. What does that mean? That means that the state has the burden of proof, and they have to prove each and every element of a charge beyond a reasonable doubt. Our professors in law school would try to instill in us, one, you don't have the burden as a defense attorney. Your client doesn't have the burden, and your client is cloaked in the presumption of innocence unless the state proves their case beyond a reasonable doubt. So our professors would always tell us, you can sit over there, you can do crossword puzzles, you can play video games, you don't even have to pay attention to what's going on. You don't have to question any witnesses. And they instilled that into us because they wanted us to be sure that we understood that as the defense, you do not have to prove anything. As the defense, your client is presumed innocent. Does everyone understand?
Yes.
So right now, how much evidence have you all heard in this case? So if you had to decide on whether Mr. Gallegos is guilty or not guilty right now, what should your verdict be? All right. Now, let's get to the burden of proof. What's the burden of proof in this case? The burden of proof is proof beyond a reasonable doubt. What does that mean? What is the definition? When I was in law school, and I'm slightly older than these attorneys, like I say, I'm 20, they probably like 19. There was a definition for proof beyond a reasonable doubt. You had to know it forwards and backwards. And if you didn't know it, you felt like a failure. I memorized that definition. I can still quote it. I knew where to put my commas when I was speaking, the explanation points. I knew where to pause for dramatic effect. And then after my first jury trial as a defense attorney, you know what happened? They did away with the definition. So there is no longer a definition for proof beyond a reasonable doubt. Now, I just told you the burden of proof is proof beyond a reasonable doubt. So you're probably asking yourself, then, how do we know if the state has met its burden or not? So as a defense attorney and as a prosecutor, I said, you know what? The best way to explain it to a jury is by telling them what it is not, so they won't lower the burden. So next door, you have the historic courthouse. That's the courthouse with the green rooftop. Over there, they try civil cases. So fender benders, when you see people on the freeway and they get bumped from behind and they don't want to move to the emergency road because they think they're going to get $1 million and it's just a fender bender. Those cases are tried next door. And the burden of proof is preponderance of the evidence. What is that? More likely than not, something happened. So if you're ever in a criminal case and you're deliberating and one of the jurors said, well, I believe this happened more likely than not, you need to tell them, excuse me, we're in the criminal courthouse, we're not on the civil side, you're at the wrong burden of proof. That's their first burden. Their highest burden next door is what's called clear and convincing evidence. Clear and convincing evidence is the type of evidence that is used to terminate people's parental rights. What do they say? They say that you're a danger to your children, so you will no longer be allowed to legally be their parent, and they terminate your rights. And I think everyone here would agree that should be a high burden. If somebody's going to come up and take my children away from me for the rest of my life, well, it is a high burden. But you know what's higher than that? Proof beyond a reasonable doubt. That's the highest burden we have. Does everyone understand? Now, there are two phases to a trial. First phase, people love to call it the innocence phase. That's not correct. It's not an innocence phase. The first phase is, did the state prove their case or did they not prove their case? That's it. It's not, oh, is the person innocent or not innocent? No. It's, did the state prove their case or did they not prove their case? So if the state doesn't prove their case beyond a reasonable doubt, what should your verdict be? Oh, y'all are very quiet. Y'all need to, let's wake up. If the state does not prove their case, then what should the verdict be? All right. So if your verdict is not guilty, then there's no phase two, because phase two is correctly called the punishment phase. And in phase two, you decide somebody's punishment if you found them guilty. In this case, the range of punishment is up to a $10,000 fine. Usually people get stuck on a $10,000 fine. $10,000 fine doesn't go to a complainant. It goes into the coffers somewhere in the multiverse. All right. But the other range is anywhere from 2 years in the prison up to 20 years in the prison. What does that mean? That means you could potentially sentence somebody to 2, 3, 4, 5, 6, all the way up to 20. Also, there's a possibility of probation. So that is the range of punishment for this type of case. Does everyone understand? Has everyone internalized what the range of punishment is?
Yes.
So attorneys will always ask you, well, can you give 2 years in this case? Can you give probation? Can you can you give 5 years? That is an inappropriate question. The only thing they're allowed to ask you is whether you can consider the full range of punishment. And the full range of punishment for this type of case, if you find someone guilty, is anywhere from probation up to 2, 3, 4, all the way up to 20 years in prison and up to a $10,000 fine. Does everyone understand?
Yes.
Now, usually when people saying can you consider the full range of punishment, it never fails. Jurists like, well, I don't know if I could give that. That's not the question. The question is whether you can consider the full range of punishment. And for some jurors, and if I were a juror, it would be me too. I would say, if I wasn't in the legal field, I would say, if I know the facts of the case, then I would be able to tell you what I would give. Well, guess what? You're not going to know the facts of the case unless you're on the jury. So with regards to the range of punishment, everyone has told me that they've internalized the range of punishment. They know what the range of punishment is. So if someone were found guilty of this type of offense, the question becomes whether or not you would take whatever facts were given to you and use those facts to come at a range of punishment, if you can come at a range of punishment. Does everyone understand? So is there anyone here who would be unable to do that? All right. Now, the next thing I want to talk to you about is fairness. Attorneys will always ask you, this is the type of case this is. Are you able to be fair? Can you be fair? And people are like, I don't know. So let me explain to you what fairness is. Let's say, you have jury duty and you're going to do your civic duty because that's who you are. You're an American, and by goodness, you're going to do your civic duty. So what you do is you get up the day before you have jury duty and you do a dry run because you want to see, is there another construction that has mysteriously popped up? So you take the route, you look at everything, you know where you're supposed to park, you know where you're going to be coming, you've done the dry run. So the day it's for you to start jury duty, you get up in the morning, the weather is nice. It's 72 degrees in San Antonio in the summertime. There's a slight breeze. You're like, why do I have the AC on? I don't even need the AC. The weather is so perfect. You get up, you fix your breakfast, the birds are chirping, you come downstairs, and your vehicle is on cinder blocks. But you're going to do your civic duty. So you get an Uber or Lyft, or your neighbor takes you, you come downtown, and you're standing outside in the cool hallways, waiting to be called in. You come in, and I tell you, okay, we're here for a burglary of a vehicle. Usually people will say, you can't be fair, can you? This is what fairness means. Even though your vehicle was burglarized, are you going to hold it against someone who's accused of burglary of a vehicle? Are you going to say, you know what? I'm not even going to listen to the facts presented. My vehicle has been burglarized. And this person is charged with burglary of a vehicle. I'm just going to find them guilty. I don't even care. That's what fairness means. Fairness is basically this. Are you able to listen to the evidence that is presented to you? And if you can come to a decision, base that decision upon the evidence that is presented. Is there anyone here who cannot do that? Now, the next thing I want to talk to you about is intoxication. Raise your card if you have ever, you believe, drank to intoxication before. All right, I should ask the reverse question, right? But no, keep your card up. I'm going to call your number. So it's 3, 4, 6, 8, 9, 11, 14. And when I call your number, you can lower your card. 15, 16, 20, 21, 22, 23, 24, 25, 26. Don't be shy. 26, 27. You can lower your card. 31, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 45, 46, 50, 51, 55, 54, 58, 59, 61, 62, 63, 64, 65, 66, 66, 69, 70, 71, 72, 73, 74, and 75. Raise your card if you have ever been the designated driver. Oh, the same people who had all right. All right, designated drivers, 1, 6, 7, 8, 9, 11, 12, 14, 15, 17, 19, 20, 22, 23, 24, 25, 26, 27, 29, 31, 33, 34, 35, 36, 39, 40, 42, 43, 44, 45, 46 through 48, 49, 50, 51 through 56, 58, 57, 61 through 64, 65, 66, 69, 70, 71, and 72. All right, raise your card if you have ever been around anyone who was intoxicated and you felt they needed your protection. Number 1, 3, 6, 7, 8, 9, 11, 12, 14, 16, 17, 19, 21, 22, 26, 28, 29, 30, 31, 33, 34, 35, 36, 38, 40, 41, 43, 45, 46, 47, 41, I've called you, 48, 51, 53 through 55, 59, 60, 57, 61, 63, 64, 68, 67, 69, 70, 71, 72, 73. All right. Raise your card if you've ever had to defend physically someone who was intoxicated. That's number 3. Number 6, 21, 22, 36, 38, 48, 59, 61, 63, 67, 69, and 72. Of those who raised their card for that last question, raise your card if it became violent. You're defending the person. Number 3, number 6, 21, 22, 48, 61, 63, 67, and 72. And 15, you don't have your card up, correct? All right. So I'm expecting this trial to conclude no later than Friday. Is there anyone who has any type of time constraints with regards to that? And let me explain to you. Testimony would likely begin tomorrow at 1:30. So if you have a time constraint, please raise your card. That's 6, 21, 26, 27, 2, 9, 22, 32, 35, 36, 37, 41, 53, 58, 63, 72, 75, 73, and 69. Number 2, what's your time constraint? All right, so you're all gonna have to speak up so the court reporter can hear and I can hear it. Yes. Where to? Where to? All right, and when are you proposing to leave? And you say in the morning, what day is this? Friday? All right, number 6.
I have work. I started a new job recently and I'm still in training and there's really no way to pick up what I'll be missing.
All right. Number 9.
I have to, my daughter, I have to move in my daughter to her dorm, which is in Lubbock at Texas Tech. So I need to move in Friday and Saturday.
What time Friday?
Well, we're eligible to get in there as early as 8 a.m.
But when would you be leaving to Lubbock?
Night before, Thursday night.
Mhm.
So that we spend the night, get there Friday morning, move early Friday all day, Saturday all day. That way she can start her summer courses.
All right, and that is not an SCC team, is it?
No, it's a
All right, number 21.
That's financial constraints I have to work in the provider of my household. Commission based employees, so my absence is like, presence there.
All right, number 22.
I've got reservations at Rockport. Already up there, it'll be ready. Leaving around noon on Friday.
All right, what are you doing in Rockport? Okay, I thought fishing. So, what type of fish?
Anything we need.
Okay. Thank you. All right, number 26.
Work and got cows that are calving and we got the screw worm right there. So.
All right, thank you. Number 27.
Work.
Thank you. 32. I'm sorry, what? All right, thank you. 35.
It's, you said 1 o'clock? My appointment's at 8:30, so it should be fine.
All right, thank you. 35.
Oh, that was.
I'm sorry, it was 36.
Work sole provider for family of 5.
Thank you. 37. I'm sorry, I didn't hear you up. You say you have no transportation.
So it's really someone else.
All right, and a manager where?
Sonic Garden?
All right, thank you. Number 41.
My parents are elderly and they're on vehicle wise and they're also watching my mom. Doctor's appointments this week.
All right. 53.
Going out of town tomorrow.
And where you seem very happy about that. Where are you headed? All right, when? What time? And when you say we're going, who is we? Okay, you're leaving your family behind. Okay, all right, thank you. Number 53. Oh, I'm so sorry. I'm getting different numbers up here. Number 58.
Work/doctor's appointments. I'm the PCP for homeless vets in this area. And multiple appointments within the schedule.
All right, and when is your doctor's appointment?
It's not for me, it's like I'm taking care of patients,
Okay,
so morning, noon, unfortunately, night.
all right, number 63.
I'll be going out of town to South Padre / Port Isabel. I am hosting a wellness event for the community there.
I mean, do you want to do that? I mean, is it hosting a wellness event? Isn't that sort of like dealing with other people's problems?
Got it before I walked in, Karen TV5 would like me there at 2 on Friday, to promote the event.
All right, thank you. Number 72.
Yes, I'm operational owner for 2 bars on here in San Antonio want to come out, and I'm just at my peak season right now, so very short-handed.
All right, so you say 2 bars?
Yes, ma'am.
All right, and what is that? I mean, I know what a bar is, but what are the bars' names?
The Rose of San Antonio downtown and then River Rose Tavern and Canyon Lake.
All right. All right, and in your occupation, have you ever,
Yes, ma'am, I've been doing this 30 years.
have you ever dealt with people who were intoxicated?
Yes, mostly on a daily.
And have you heard of a Coca-Cola drink where you put wine in it or something? Yes. Okay, I'm just wondering.
Keeping up with all of the products.
Okay, and I'm sorry, what was your number again?
72.
All right, thank you. Number 75.
I'm a registered case manager. I'm starting to.
All right, thank you. And then 69.
Stitches in the top of my head that are coming out on Friday at 9:30.
All right.
Scheduled.
That is so nice of you. Thank you.
All of that stitching.
Oh. All right, number 73. All right, thank you. All right, so next thing I want to ask, raise your card if English is not your primary language or your first language. All right, that is 46, 63, and 67. Oh, and 47? All right, 46. Yes. What is your first language? All right, thank you. Number 47. All right, thank you. 63.
Spanish.
67. Thank you. And have all of you been able to understand everything?
Yes.
All right. I always ask that question because sometimes, believe it or not, we will have people or we've had people and they haven't understood certain things because of a language barrier. I was never supposed to be in Texas. So of course, when I was in junior high, now you call it middle school, my best friend was like, Stephanie, you and I, girl, we need to take Spanish. I'm like, I'm never going to need that. I'm like, we're in Louisiana. I'm taking French. I'm going to be retired in Paris by the time I'm 21. And lo and behold, I ended up here after undergrad and grad school for law school. And I'm like, curses, I should have taken Spanish. So I've been working on it. If my Spanish is not what it should be, then you can blame the deputies because they're supposed to teach me. And so far, all I got is de nada. So we'll work on that. Now, the next thing I'm going to do before I turn it over to the state and defense to ask you questions, and they each will have 30 minutes to ask you questions. I'm going to tell you 2 stories, and both of them are true. I will always see people who don't want to serve jury duty, right? And I tell people jury duty is an inconvenience, it's not a sacrifice. Why do I say that? It's an inconvenience because 1, you got to pay for parking. And you're probably thinking, I'm doing y'all a favor and y'all are making me pay for parking. All right. So, and then you have construction. And they're constantly doing one ways downtown because somebody did a study at one point who thought if you have a bunch of one ways, that'll make traffic flow easier. And it really doesn't, because you'll see where you're supposed to park and you can't turn because it's one way. And then it's sort of like a hurry up and wait. So I tell people that's an inconvenience. This is what I consider a sacrifice. So my family grew up in a small town called Grand Cane, Louisiana. And my uncle, super intelligent. Before this computer thing became like just common, he already knew about computers. And so my grandmother would send him to school, and the teachers would tell him, Miss Lane, we've taught him all we can teach him. And they would send him to the next grade. And that was back in the day, maybe because the schools were smaller, the classroom size were smaller. The teachers not only knew every student in their class, they knew every student at the school. Now, when my aunts and my other uncle went to high school, they were not very happy with my uncle because the teachers told them, this is the gold standard. Now we know where he comes from. This is what we're expecting for everybody. So my uncle graduates from high school and a conflict breaks out. You may have heard of it, called the Vietnam War. And he goes to my grandmother and he's asking my grandmother to approve him entering the military. And he tells my grandmother, because what's happening with civil rights, there's no way for me to improve my lot in life here. And so that was my grandmother's firstborn. And she had to sign to send her child off to a place that she had never heard of before. And my grandmother was super intelligent. She only had a 6th grade education, but she babysat me. She taught me how to read, tell time while my mom was at work. She taught me how to tell the insurance salespersons that would knock on the door, no, thank you, we don't want any. I did say yes to the childcraft books and the encyclopedias, which I still have. My mom was shocked by that, but she allowed me to have those. So that was back in the time where there were only 3 stations. This whole thing with young people where you say, oh my gosh, there's so much on television. They're playing the same thing over and over. Well, back in the day, you only had 3 stations, ABC, CBS, and NBC. NBC, you really couldn't count on. If there was a breeze, don't even let it rain because you're not going to be able to get that channel. And then it wasn't 24 hours. At some point, the programming would end. And then when they got high tech, they would play the national anthem and the flag would be blowing in the wind, or either you just have static and you'd have to wait for the next day for news. And my grandmother did have a phone, but her phone didn't have any numbers on it. And young people were like, well, how do you talk on that? I always tell people, you can tell what era people were born in by looking at their index finger. I'm the rotary era, because you're trying to win the contest from the radio station. I was so happy when we finally got touch tone with the redial, because you're like, I'll get it down. So my grandmother would pick up the phone and the operator would answer and you tell them who you wanted. That's why you would have songs like Beechwood 45789, because you want the person who's at Beechwood 45789. So my grandmother had of course, his name and the number they gave him from the military. And she would send letters to him and she would have to wait the letters to come back. And Grand Cane, small country town, so it would have to go through the big city, Shreveport, Mansfield. And if you look up those cities, they're not anywhere near as large as San Antonio. So she would wait to get letters back from her firstborn son, who she's sending off to fight in a war. And I would always end that story at that point until the deputy said, Judge, what happened to your uncle? Because my grandmother's like, hey, there are people in military uniforms knocking on other people's door. This is not good news. Well, my grandmother got a knock on her door about her son from people dressed, and they were dressed in uniform. And she learned that her firstborn son was severely injured. He ended up surviving and he continued to remain in the military. And he would always come back. And because at that time I was the youngest niece, He would always come back from wherever they had stationed him and bring me a gift back, give me a hug. That is why whenever I smell Old Spice, it makes me think of him, because back in the day, that was your male rite of passage. You can now wear Old Spice. But he has since passed. Some of my aunts have since passed, but I always remember that. And so I always tell that story to tell you that this, what you're doing right now, it's an inconvenience. It's not a sacrifice. I always see people 4th of July, Memorial Day, Veterans Day. You want to wave your flags, and then your country asks one thing of you, to serve on a jury, and people don't want to do it. So raise your card if you have ever served on a jury and actually listened to testimony. So that's 1, 5, 7, 13, 17, 26, 27, 31, 39, 40, 48, 51, 60, 64, and 75. So raise your card if the trial that you sat on was in Bexar County. That's 5, 13, 7, 26, 27, 31, 39, 40, 51, 60, 64, and 75, and 27. Raise your card if that was a criminal case. That's 5, 7, 13, 1, 31, 64, 75. Raise your card if a verdict was reached in your case. 1, 5, 7, 13, 17, 26, 27, 31, 39, 40, 48, 51, 64, and 75. Now, each side will have 30 minutes to speak to you. My friend and I, who went to law school together, she does civil work. No offense to the civil attorneys, but usually they're not in trial every week and they're not in court every day. So she got called up for jury duty and she said, Stephanie, let's do lunch. I'm like, great. And it's like no time had passed since the last time we were in law school together. So I asked her, how is jury selection going? She tells me it's going fantastic. I'm wondering, how could it be going fantastic? What do you mean? She said, I'm not going to be selected. It's just like law school. I'm keeping my head down, not answering any questions. So I start laughing. She says, what's funny? I'm like, I'm just happy because we're going to have lunch together all week. So other than remaining quiet, the quickest way to be on a jury trial is to raise a card and say, please put me on this jury. I desperately want to serve. The state and the defense, regardless of what you've seen in television shows, they only have 30 minutes to talk to you. They don't have anybody to go out and look through your trash can or anybody to, go to your house for dinner to find out who you are. This is the only time they will be able to do that, okay? Does anyone need a break before I turn it over to the state? All right, we're going to take a break. Do you all want a lunch break or a short break? All right, so I'm going to give you all a 10-minute break. Look to your left, look to your right. You're responsible for making sure that juror is in line. So please leave the cards behind. And when one person leaves, everyone must leave, and you're going to be lined up outside. Don't come back into the room, okay? Everyone, please rise for the jurors.
No. Very well.
He's listening to find out. We have to see. I think he wants to find out. And you first.
All right, everyone, please be seated. State, you may proceed.
I think we may be missing one.
All right, who is responsible for 34?
Might not know where that we're called in, because we couldn't hear it back. There was another jury selection out there.
All right. Deputy, could you make an announcement in the hallway for 34 for the 187th? Do I have parties approach? Ah. Okay, that's okay.
So want to approach judge or?
Yeah. Yes. All right, State, you may proceed.
Thank you, Doug. Morning, everybody. So, before I begin, I must apologize. I have a 4-year-old who's going through such a quick sleep regression right now. He is like a teenager. He's staying up till 10, 11 o'clock and will not wake up at 6:30 for school. So I'm running on 4 hours of sleep, 4 shots of coffee over there, and the cracks and caffeine, all things are possible. But if I'm a little jittery today, I just apologize. But real quick about myself, my name is Brian Prater. I'm gonna be the first year prosecutor on this case with Ms. Espinosa. This is gonna be like our third, fourth trial together, so we're doing this again. Let's see, at this point, I have been a prosecutor, I've been a defense attorney, I've been a bailiff and a sheriff deputy before that. The only thing I have not done is court reporter because my hands are too slow, judge because my wife said not yet, and on a jury actually. So y'all will be able to do something that is on my legal lotto list. So let's get to it then. So what are we here for? We're here for the case against state against Randy Gallegos. So quick tips, basically judge already ran through these. There's no judgment here. What judge is saying about we want your opinion, this is what our only time to be able to talk to you. We do want your honest opinion. We want your truth about things. It's kind of like Planet Fitness. There ain't no judgment here. If you have opinion that you feel may insult me or the defense or anything like that, I'm a sheriff deputy. I've been called every name in the book and enough to have a few chapters after that. So I will not be offended. Please give me your honest opinion. We want to know. We want to know. Second part, what your means to tell the truth. Kind of same thing. We want your opinion. We want you to tell the truth. Third thing, we can't even get into specific facts of the case, just like Doug said. And the big one, potential jurors who are quiet are way more likely to get on the jury. So if you really want to be on the jury, but so what are we here for? Aggravated assault. Texas Penal Code 2202. This is the specific number of the law and states a person commits an offense if the person commits assault, i.e. threat with imminent bodily injury, and the person causes serious bodily injury to another. And our burden, this is what we have to prove to y'all. On or about September 26, 2022, Randy Gallegos did intentionally, knowingly, and recklessly cause serious bodily injury to Peter Rios by striking the complainant with the foot of the defendant, striking the complainant with the body of the defendant. That is what we have to prove to you beyond reasonable doubt. Everybody tracking? Good. So intentionally and knowingly, what do those mean specifically? So intentionally, this is straight from the penal code. This is the law. A person acts or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause a result. So let's say that we go to trial, I don't do something that Ms. Espinosa likes, she gets very upset at me, points a gun at me and fires. Bang!
She knew what she was doing. She pointed the gun at me. She pulled the trigger. There was no accident, nothing like that whatsoever. Does that fit the definition of intentionally? There was her conscious objective to shoot me. She aimed the gun, she fired the gun, they struck. Let's go to knowingly. A person acts or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. So let's say, same thing. Lauren is very upset with me. She points the gun at me, but she's squeamish, she doesn't see the blood, so she turns away, fires, bang, shoots in my direction, still strikes me. She knew, she was aware that her conduct was reasonably certain to cause the results. Does that track with everybody?
Yes.
Alright. So, intent. How do we prove intent? Well, it's gonna be totality of the circumstances, the defendant's actions and their attitudes. Basically, it's gonna be everything around what the defendant did. Does anyone hear a mind reader? Anybody psych? Alright, jury number. So, we have not evolved to be able to read anybody's mind just yet. But what can we do to kind of see around what a person is intending? We see their actions, we see what they're doing, we see what they're saying, and from that, we can infer what their mental state is, what their intent was. So it kind of looks at the totality of the circumstances of the case. Everybody tracking? Okay, good. All right, what is bodily injury? So this is a big one. Physical pain, illness, or impairment of physical condition, not emotional. Words may hurt, but they are not physical pain. Any physical marks necessary to prove injury? Based on the definition, physical pain, illness, or impairment of the physical condition? Let me ask the gentleman here. The gentleman here, have y'all been struck in the testicles?
Yes.
Does that hurt?
Yes.
Does it leave marks?
No.
Would that be physical pain?
Oh, yeah.
There you go. That is bodily injury. Pain alone is enough under the law. So does anyone need to see blood for there to be physical injury? What about bruises? Pain alone is enough, right? There you go. Now let's get to serious bodily injury. Bodily injury that creates protracted loss or impairment of the function of any bodily member or organ. So let me ask y'all, with that definition, what do y'all think would be a serious bodily injury? So Cynthia is taking down everything that everyone is saying. So if I want to speak up, hold the card up and then stand up. Can you stand up so Cynthia can?
A broken arm?
Yeah, something that's broken, right? Because when your arm is broken, can you still use it?
No.
Yeah, it's protracted loss. Does anyone else feel the same as number 63? Anyone disagree that a broken arm is not a serious bodily injury? All right. So this is going to be the first what's called a kind of stilted question. So basically, it's going to divide everybody into 4 groups. So a jury's verdict on a violent case can change behavior in the community. 1, strongly disagree, will have no effect on the community. 2, disagree. It's only about the defendant on trial. 3, agree. When the public hears the verdict, they will make.
Excuse me, counsel, you're talking too fast.
I am so sorry, John. I'll slow down. Or sorry, Cindy. Or 4, strongly agree. Strong verdicts deter future crimes. So take a moment, read this. You see what we're doing? Yeah. So, who will put themselves in group number 1? Strongly disagree. The jury's verdict on a violent case will have no effect on the community. All right. Who put themselves in number 2? Disagree. A jury's verdict on a violent case is only about the defendant on trial. All right. So we have. Okay. We have 1, 2, 3, 5. Thank you. And when I call your card, you can put it down. It takes a lot to keep that card up for a long time. Number 9, 16, 17, 20, 26, thank you, sir. 36, 37, thank you, Matt. 43, 44, thank you. Your card backwards, man. Okay, thank you, appreciate it. 51, 54, and 55, thank y'all. Whoa, there we go. Are you good? Are you holding up your card?
No.
Okay, I'm so sorry. 61, 62, 63, and 64, 65, 66, 7, 8, 9, memory cards. There you go. No, you're fine, fine. Yeah. 72, 73, and 75. Okay, thank you. Who put themselves in group number 3? All right, so we got 4, thank you, sir. 6 and 7, you. 8, 10, 11, 12, 13, 14, and 15. 19, thank you, ma'am. 1, 3, 4, 5, 7, 8, 30, 31, 32, 33, 4, 35, 38, 39, 40, 42, 46, 47, 49, 50, 51. I'll come back to you in a second. Okay, 51, 52, 53, 6, 7, 8, 9, 66, 70, 71, and 74. Okay, I didn't forget about you. What was the question?
I thought you had asked if we, if we agree that this is about person. Agree that be that part.
Okay, do you want me to read it back to you?
Yes.
Okay, so basically on this one was a jury's verdict on a violent case can change behavior in the community. Agree when the public hears the verdict, they might make different decisions. Was that the one you were agreeing on, or was it 2?
It was one that said that the verdict based on.
Yes, ma'am, that would be disagree, it's only about the defendant on trial. Like the public is not going, your opinion is the public is not gonna worry about it, it's only about the defendant, it's the on trial. So you put yourself at number 2?
That I agree that it's only about.
Okay. Okay, thank you so much, appreciate it. All right, and who would be in group number 4? Strongly agree, strong verdicts deter future crime. Let's, so we got 22. All right, wow. So
I'm gonna object to 3 and 4 as being improper question.
What is your question?
I'm objecting to 3 and 4 as being improper commitment questions. I want to know it on the record.
I'm like, what is the question that he asked that you deem as a commitment question?
He's suggesting that the verdict may be going one direction, as it leaves out the idea that there could be a not guilty verdict.
No, I mean, what is his question? State, what was your question?
my question was whether they can put themselves into group number 3 or 4. Basically, a jury's verdict on a violent case can change behavior in the community. When the public hears the verdict, they may make different decisions, or strong verdicts deter future crime.
All right, the objection is overruled.
Thank you, Judge. All right, so let's go. Right. Yes, can you see that quick? So, what is that?
All right, so here's the thing, people need to stand because Cindy can't hear.
Can you take a good long picture of what's?
Brandon, can you get the microphone, please, and pass it over?
Please speak up. I've got a pretty loud voice. It's a puzzle of an elephant. It's missing 3 pieces and it looks like the elephant's taking a walk.
Okay, but there are other pieces missing,
Yes, 3.
but you're sure it's an elephant?
Pretty sure it's an elephant, yes.
I mean, you don't have all the pieces there. Can you say beyond a reasonable doubt that what's pictured there in that puzzle is an elephant?
I've never seen feet like that on another animal.
Is there any doubt in your mind, even with the public pieces missing, that is enough? Would any of those pieces, if they were filled in, change your mind? Okay, and that, ladies and gentlemen, is proof beyond a reasonable doubt. It's not proof beyond all doubt. It's not proof beyond a shadow of a doubt. It's not proof beyond an unreasonable doubt. I'm not going to be able to give you everything, because if I had everything, it would be proof beyond all doubt. There are going to be pieces missing. What I'm going to be able to give you through evidence and through testimony is going to be the puzzle. It's gonna give you enough to be able to think with your own minds, because I'm trusting y'all to think, and I want y'all to think when y'all are in the jury box. To be able to see what's in front of you, have the testimony in front of you, and be able to say, yeah. We don't have everything, but what we have is enough, I'm convinced, beyond a reasonable doubt. Yes, ma'am, Journal 44. Oh, I'm so sorry. Do you want me to back up or re-explain it?
No, it's just, I'm trying to comprehend what you're saying, sometimes you go before the
You're not the first person to say.
yeah.
I'll slow down. I'm so sorry, y'all. Okay. So, and this applies to all the elements of the case. So, like we were talking back there, Randy Gallegos, on this day in Bear County, caused serious bodily injury by striking the complainant with foot of the defendant or by the body of the defendant. That's basically what I'm gonna have to prove beyond a reasonable doubt. Everybody good? And here's one last big one. So, if the case is proven beyond a reasonable doubt, the only legal verdict we can come back with is a verdict of guilty. Must convict. So, like Judge was saying, presumption of evidence holds right now. So I've given y'all no evidence. I've shown y'all no testimony, done no videos, nothing like that. The only verdict I'm coming back with right now is it's not guilty. But let's say y'all get into the jury box, I put on my case is proven to you beyond a reasonable doubt. The only verdict you can come back with now is guilty, right? Is anyone unable to do that? The case is proven beyond a reasonable doubt, they could not convict. Oh, that's. I've been on 64, okay.
I'm going back to your,
Stand up for the.
yeah. I'm going back to where we talked about that you don't have to see physical evidence for there to be bodily injury. And I don't worry.
So you
Maybe some kind of injury is going to be some kind of mark, some kind of lead mark or raised mark and study gentlemen. I can't say from firsthand experience, I've not seen that with my own eyes. So.
okay, so I just want to clarify, thank you for telling me the truth, but just paint a little would not be enough.
That's right.
Okay, perfect, thank you very much. Does anyone else feel that way? Juror 44, thank you. Same thing, you would need, if it was proven beyond a reasonable doubt, but it was just pain, you wouldn't be able to convict? Okay, and juror 75, same thing?
Excuse me, could you all approach? Understand what the law is in this type of case. Does everyone understand what serious bodily injury means? Is that a yes or no? Who's saying no? All right, your juror number 44 and 64. All right. Because I know there have been questions about the feeling of pain, right? Now, in some cases, when we're talking about feeling of pain, if someone says someone hit them with their fists, sometimes if someone is hit with the fist in the arm or whatever, there's no bruising. But the person may say, hey, you know what, that hurt. Now, sometimes there are different degrees of hurt, right? Sometimes people can say on a scale of 1 to 10, you know, when you go to see a doctor, on a scale of 1 to 10, what is your pain? Is it at a 1? Is it at a 0? Is it at a 10? So in the law, if you're saying there was physical pain to you, and that on a scale of 1 to 10, it's at a 1, then it's still physical pain. The question would be whether or not you believe testimony from whoever is testifying saying, I felt pain. Now, if somebody tells you they felt pain and you don't find them credible, then maybe you're like, yeah, I don't believe you felt pain from that. Does everyone understand? Now, let's talk about serious bodily injury, because a couple of you raised your hand and said, I'm not too sure what that means. So, serious bodily injury under Texas law can mean several things, or there's several ways to prove it. Number one, the injury you suffered, is there a risk that you may die from that injury? Like, for example, let's say you get a skull fracture. Is it possible that you may die from that injury? All right. If you are stabbed with a knife, is it possible you could die from that injury? Permanent disfigurement. Let's say someone burned you. Let's say they threw some hot oil on you. You may not going to die from that, but you may get blistering and you may end up with a permanent scar, right? If there's a loss or impairment, what do we mean by loss of impairment? Let's say your leg gets broken, your arm gets broken, and the doctor says, hey, we're going to put that in the cast. You can't use it. That means you've lost use of that body part. Does everyone understand? So that's what serious bodily injury means. So serious bodily injury is a higher level of injury than just feeling physical pain. Now, under Texas law, when you're talking about bodily injury, not serious bodily injury, but bodily injury, that's where it's like, okay, I don't see a scar, I don't see a bruise. How is this bodily injury? Then under Texas law, bodily injury can mean, hey, this person hit me and I felt pain. That's my injury. I felt pain. Does everyone understand?
Yes.
Does that clear that up for everybody?
Yeah.
Anything that anyone doesn't understand from my instructions or my clarifications or attempt of clarifications? So what I'm going to tell you is the state and the defense, they can speak to you about anything they wish to speak to you about during this process, but the law comes from the court. Does everyone understand? All right, state, you may proceed.
Yeah, I think juror number 64 had a question for you.
Yes, juror number 64.
Not so much as a question as a statement. I understand that that might be what the law says, but what if I don't believe it? What if I don't believe that that is a good and just law?
Oh, so here's the thing. We all have opinions, right?
Yeah.
And you can think, for example, you can say, you know what? I don't think there should be a law against people using marijuana. People should be able to smoke as much as they want to smoke in the comfort of their home, right? That's fine for you to believe that. But when you're in the courtroom, the law says that's illegal. So the question becomes whether or not you're able to follow the law. So jury number 64, you say you don't believe that that should be enough for bodily injury. The question becomes whether or not you will be able to follow the law that I give you. So will you be able to do that?
I will try.
Okay, so here's the thing. In the courtroom, we don't try, we do, right? So let me give you a perfect example. One, this is a very important case to both sides, and both parties want a fair jury. Let's say your significant other is going to Vegas with their friends. And you're like, honey, have a great time. You drive them to the airport. They have their carry-on. They're only going to be there for like 2 days. They kiss you goodbye. And as they're getting ready to check in at the ticket counter, you say, just have one question before you go. Do you love me? And they're like, yes. And then they say, are you going to cheat on me? And your answer to their answer to you is, I'm going to try not to. I mean, you want to accept that, right? All right, so in this case, whatever answer anyone gives, guess what? You get an A plus. So in this court, we can't try, we must do. So I'm telling you what the law is. You may disagree with the law, but the question is, will you follow the law? Okay, will you follow the law? All right, and someone else had a question? 59.
I wanted to make sure that there was any confusion between, because you had stated that, and like, don't have any marks, that it could be a bodily injury, or you saying no marks could be a serious bodily.
All right, so let me just explain something to you. Serious bodily injury and bodily injury are not the same thing, because one has serious bodily injury before it and one is just bodily injury. So when you have somebody who just has bodily injury, that could be an injury, yes, where somebody has a bruise on their arm. The bruise on the arm may not be a serious bodily injury, right? Now, you may have someone who has an injury, a bodily injury, and there's not a single mark on there. But they're like, hey, there's not a bruise, but I felt pain. Oh, I just put some ice on it. On a scale of 1 to 10, it's a 1. That's bodily injury. Serious bodily injury is a higher level injury. Like I said, it's risk of death, impairment or loss of use. Does everyone understand? And permanent disfigurement. Like, for example, maybe somebody cut you and now you have your eye, but you can't see to the left. That may be considered serious bodily injury because you have a permanent disfigurement and you have a loss of use of something that you had use of before. Does everyone understand? All right, State, you have 13 more minutes.
Thank you. So, evidence. Reality versus fiction. I wish that we could just have this all wrapped up nice, neat, and clean, CSI in an hour. But unfortunately, that is not the reality. So let me talk to you about video evidence. Many crimes are documented through security footage or through phone cameras. But let me ask you, crimes always happen in places that have video cameras?
No.
Are there places that don't have video surveillance footage?
Yes.
Can crimes happen there? Is there gonna be video of what happened? Exactly. So criminals don't like to get caught, and cameras are a really good way to get caught. So they try not to commit crimes where cameras are. So let me ask y'all this question. And remember, the case is proven beyond reasonable doubt. You must convict, you must come back guilty, right? So if this case is proven to y'all beyond a reasonable doubt, without video, who here would still need to see video in order to come back guilty? Juror number, could you hold up your card, my friend? Juror number 41? Okay, thank you, my friend. Does anyone else feel the same way? All right, thank you. Witness testimony. So witness testimony is evidence. Witness testimony is considered as evidence just like video, pictures, 911, and all of the records are considered evidence. When a witness gets up there and they start talking to you about what they saw, what they observed, what happened, that is the exact same as if there was a video in front of you, as if there were photos in front of you, as if there were documents in front of you. It's all the same quality. Everybody good? All witnesses start equal. When someone gets up there, you don't know them, they haven't started talking yet, they may have a uniform on, they may have a suit on, they may have jeans and a t-shirt. Wouldn't be considered good courtroom attire, but they're up there. They all start off equal. It's up to you when you're in the jury box to determine their credibility. You can consider their experience, their qualifications, and all of the factors, but, and this is a big but, you must wait to hear what they have to say first before you determine their credibility. If you see somebody go up and start on the witness stand and they're bald or have a beard and you just don't like that, you can't hold that against them as well. He has a beard or she's wearing like a tank top or something like that. I don't like that. They're automatically a liar. Is everybody good with that? We're gonna hear what they have to say first and then decide how credible they are. Well, good. All right. So witness memory. Let me ask, okay, so who had breakfast today? All right, a lot of people. Okay, y'all remember what y'all had for breakfast today? Y'all remember what y'all had for breakfast yesterday? Y'all remember what y'all had for breakfast Tuesday, a week ago? You remember what y'all had for breakfast? Let's see, we're in June, or no, sorry, we're in July. What about on May 27, 2025? Y'all remember what y'all had for breakfast that day? Did y'all even have breakfast? So, does time play tricks on memory? Absolutely. So this is gonna be a question for the ladies in the audience. Ladies, who in here is married? Raise your cards. Okay. So congratulations, first of all. So, who in here has been married like 5 years? 10 years? 20? 25? Congratulations, well done. Let me ask y'all remember your wedding day? Okay, now, y'all know your husband's wife, right? Y'all love your husbands? Do you think that your husband's memory of your wedding day is the same as yours? What about your maid of honor? Do you think that her memory of your wedding day is the same as yours? What about your in-laws? Do you think their memory of your wedding day is the same as yours? Were all of y'all at the same events? Why would the memory between different people be different? Exactly, perception. Different people can be at the same event and see very different things. The fact that people remember things differently mean y'all didn't get married? Exactly, what happened, happened. The only difference is perception. And that goes towards witness memory as well. So, does anyone in here think that memory is like a recording? Yeah, I've heard the quote that memory is more artist than it is camera. We tend to fill in details. We tend to remember the broad outline of things, but when we can't remember something, the mind invents. The mind paints in the picture. Can other things affect a witness memory? Like they were injured, they were in a serious situation. Has anyone heard of the fight or flight response? That's adrenaline coursing through your body. I've had it as a sheriff's deputy. I can tell you that the adrenaline rise and fall, it is a thing. It is wild to remember when I remember, and then I look at my body camera, and I'm like, this is wildly different. So, can different things affect a witness's memory? Does that take away from what actually happened? Exactly. So this is going to be my second question. Everyone has an opinion on law enforcement. What is y'all's? So this is going to be the same thing as the other question. With group number 1 being strong and negative. It's okay, like I said at the beginning, it's okay if you have a negative opinion on law enforcement. I will not be offended. Please let me know. And then going to negative, and then group 3 is positive, and group 4 is strongly positive. So who would put themselves in group number 1? Strongly negative feelings toward law enforcement. And it's okay. Number 10, thank you, ma'am. Number 18, thank you. 41, 45, and 75. Thank you. So who put themselves in group 2, negative? All right. Number 4, thank you, sir. 6 and 7, 19, thank you, ma'am. 25, 38, 36, 55, and who put themselves in group 3, positive opinion of law enforcement? All right, so I have 1, 2, and 3. Thank y'all. 5. Thank you, ma'am. 8, 9, 11 through 16. Thank y'all. 20 and 21. 23 and 24. 26, 27. 28, 29. 30 and 31. 33 through 35. Thank y'all. 37. 39 and 40. 42, 43, 46 through 53. Thank y'all so much. 57 through 61. Thank y'all. 64, 66 and 67, 68, 69, 70, 71, 72, 73, and 74. Thank y'all so much. So who put themselves in group 4? Strongly positive opinion of law enforcement. So I've got 1, 17. Okay, thank you. 22, 54, 56, 62, and 63. How much time do we have left, Judge?
5 minutes.
Okay, so I'm gonna do this very quickly. So circumstantial evidence, let me ask you a question. Which is more? 1,000-pound boulder or 1,000 pounds of gravel? Same thing, right? Yeah, what's the difference? Yeah, it's one big rock versus a whole bunch of little rocks, right? But it's all the same thing. And that is circumstantial evidence. I can have the one big piece of evidence, or I can have a whole bunch of little pieces of evidence that you start putting them in bit by bit by bit by bit by bit, they all start to add up, right? So my dad is a former naval intelligence officer. He worked with PACOM for a long time. Basically, China, South Korea, or North Korea, whatever they were doing, he was supposed to find out. And I asked him one day when I was little, I asked him, Dad, how do you know what the bad guys are doing if you're not in their heads? They're not telling us. And he said, well, kind of like this. If you see a man in a tux and a woman in a white dress coming out of a church with rings on their hands, bells are ringing, and people throwing rice at them, what do you think just happened? They got married, right? How do y'all know that? Y'all weren't there. Is it based on your experience? You weren't there, but it has all the auspices, all the accoutrements of a wedding, right? So can you look at facts that are put in front of you, and make an extrapolation on that based on incomplete data? Kind of like with the elephant, right? You don't have all the pieces, but you can think, you can infer, and when you put it together, you know what happened. Can y'all do that?
Yeah.
So, really quick, Texas is a two-step trial process. So basically, the first part is guilt and innocence, what Judge was talking about. Basically, what we're focused on here is, did he do it? Not, I think he did it, but anything after the but belongs in punishment. Basically, this part is, did he do it? Was the case proven beyond a reasonable doubt? When the guilty comes, after that comes punishment. Now, it's not, did he do it? It's, what are we going to do about it? This is when we can talk about what's appropriate. We can consider everything. Is this a person with prior criminal history? Is this a good person, an irresponsible person? But all of that stuff, all of that sympathy that you may feel for defendants, that does not belong in the guilt innocence stage. It is strictly, did he do it? Was the case proven? Everything that would pull at the heartstrings comes in punishments. Can y'all do that? All right. This is going to be my last question. So, question 3: defendant who is remorseful should be punished less severely. Who will put themselves in group number 1? Strongly agree. Pain of guilt is punishment enough. Y'all need a second to read it? Okay. So, a defendant who is remorseful should be punished less severely. Who would strongly agree with that? The pain of guilt is enough. All right. Who put themselves in group 2? Agree. Remorse should be considered more than the crime committed. 34. Thank you. 38 and 66. Oh, and 75. Thank you. All right. Who put themselves in number 3? Disagree. Remorse is good, but it doesn't change what happened. Right. Let's, for time, I'm just going to go straight to, I'm going to assume if you're not in 1 and 2 and 4, you'll be in 3. So who is in group number 4? Strongly agree. Everyone is sorry after the fact. The 10, thank you, ma'am. 22, 57, and 65. Thank you all so much. I'll pass it over to us. Thank you, Judge.
You're welcome. All right, defense.
You need the.
Yeah.
Need to get my PowerPoint set up.
Sure.
Have a 10-minute warning, please, Your Honor.
Sure.
Court reporter asked that it's time to do it. Okay. How's everybody doing? Okay? Okay, I got 30 minutes to talk, so I'm gonna say a lot quickly. But before I do that, I want to introduce myself. My name's Austin Iggy, a criminal defense lawyer based out of San Antonio. I like to say help good people through hard times with goal restoring families. Why do I say that? Why is that my mission statement? Well, this person, his family have to get through this case too, right? Now, the prosecutors represent the community, and they have to do what they have to do, but I have to go through this with him, right? And I want him to get a fair result at the end. I represent him and his family throughout this, and we need every single person that makes it onto this jury to be aware of how serious it is for his life, okay? And you need to take your oath seriously. Please try to answer every question I ask honestly right now. Try to make them as clear as possible. If you do not understand what I say, please let me know, and I'll try to clarify it. Okay, everyone good on that? Thank you so much. This is Hannah Hawkins. She is my co-counsel. She will be with me throughout the trial. She will be interjecting, speaking, being involved. We are both attorneys working in the same firm. So we've already talked about this. I'm not going to relitigate this and re-explain it to you, but you are here to be the triers of fact. What is a trier of fact? I know there's some attorneys on the panel, and don't make me call you out. Who knows what a trier of fact is? Okay, I'm going to call you out. 52. What is a trier of fact?
All right, so everyone, please remember to stand when you're speaking so the court reporter can hear. That's good.
That's exactly right. You decide the facts. You are not here to figure out the law. Who's going to give you the law? This lovely lady here, Judge Stephanie Boyd. She's going to give you the law. She's going to be ruling on the law. And at the end, when it's time to make a judgment, she's going to give you a charge. And that charge is going to tell you, this is the law to apply to the facts that you all decide. You get to decide who's credible. It happened this way. I don't believe that. I do believe that. That fact doesn't make sense. I think that person's lying about this. I think that person's lying about that. I think that person's 100% honest, right? And can a person be truthful about one thing, but not truthful about another thing? Sure, in the blue dress, what's your name yet? Susan. Okay, Susan. Do you think it's possible that a witness can be telling the truth about one part of the story, but maybe not another?
Yeah.
Does that happen a lot?
Don't know.
Well, let me say it this way. Somebody's sometimes credible on one thing, but maybe not another.
Yeah.
Right. Honey, did you take out the trash? Yes, I took out the trash. Okay, and did you also cut the grass? Yes, to do this. And did you also put my laundry? Yes, but maybe you didn't, right? Little things, right? Certain things in testimony can end up being true in some regards, not true in others, right? Okay, so your role, the role of you as jurors, is to determine facts. Does everyone get this? Raise your cards. Okay, all right, I'm gonna move past this. So, what's your number, sir? In the white shirt, like that? 23. 23. Who are those people here? This picture. Yeah, it looks like the framers of the Constitution, people that wrote the Declaration of Independence. Okay, founding fathers, some people call them that. Founding father. And what do those people have in common?
I mean, they basically came up with the Declaration of Independence. They had a saving of, what in there.
They signed it?
They signed it, yeah. John Hancock, yeah.
Yeah, John Hancock. So that's where we get that phrase. He signed it large. And another thing they have in common, right? They're all criminals, right? They all became traitors by signing that document against England, the crown, right? They all risked their life in that moment to put all of you in these seats. Let me explain why. So, in the U.S. Constitution, Article 3, Section 2, Clause 3, the trial of all crimes, except in cases of impeachment, shall be by a jury, and such trial shall be held in the state where the said crime shall have been committed. Does everyone live in San Antonio, in Bexar County? Is there anybody that lives in Atascosa? Okay, good. We're in the right place. You are here to judge your peer. Why didn't they want just some judge or some majestic person on a bench judging us? Because they had seen that. They had seen that play out where a judge is the judge and jury, and there is no independent body that's involved. That's why you're in these chairs, because these people that risked their lives wanted you to be here.
they wanted to form a new form of government. And this is one of those important branches, which is the right of trial by jury. The Sixth Amendment further codified this in 1791. We don't need to go into the specifics of that. But why would they risk their lives? Juror number 4. Why do you think they would risk their lives? Why would they become traitors to give us a new system of government that includes a jury trial? Yeah. And do you think that we can be independent bodies? Do you think that the defense and the prosecution have the same goal right now? Do we have the same goal, do you think? Yeah, right? They're seeking a conviction though, right? And it's my opinion that a conviction is not just, we have different goals, right?
Yes.
Yeah, and if a police officer thinks that his case was brought properly, he has a different goal than I would, right? So there can be competing interests in the same courtroom. So that's why we need independent people that are not motivated for a conviction, or maybe not for a conviction, to sit down and say, well, my paycheck doesn't come from there, and I'm not getting a paycheck over here. I'm sure this and decide. That's why you're here. That's the role that y'all. And it's so critical. Okay, is everybody with me?
Yeah.
Okay, great. I'm gonna move on from this. You are the most necessary and powerful people in this jury trial. The judge is very important, but y'all are more important than her. Okay? And she knows it too. We cannot do a jury trial without you. Okay? Every single one of you that becomes on the jury, you need to pay attention throughout the case and not render your verdict until the end. Okay? Everyone's already said they can do that, but is there anyone that is struggling with that idea to not rush to judgment? Does anybody think as soon as I hear something, I might make a quick rush to judgment? No? Okay, well, that's fine. Where's your cards? Okay, 41 says that, 44 says that, 45 says that. Does everyone understand you have to listen to all the facts and evidence, hear closing arguments, and then deliberate? And everyone do that. That's remaining. Raise your cards if you're gonna wait to hear all the evidence before you deliberate. Render judgment. Okay. So, this case involves allegations of violence. Would allegations of violence and or assault impact anyone's ability to be fair and impartial to judge the facts and punishment based upon your experiences in life, on your personal life, whatever it may be? So anyone says, if I hear stuff about an assault, I'm gonna be triggered. I'm not gonna be able to focus. I'm gonna struggle to listen. I'm gonna go into fight or flight. Those types of things. And I may not hear the evidence and catch the things that other jurors aren't. Does anybody feel that way? It's okay if you do. Raise your cards. Okay, I see juror number 44, juror number 37, juror number 75, juror number 73. Everyone else says I can listen to an assault situation and kind of hear it out. We'll watch enough action movies, I'm okay. All right. Has anyone here been part of a jury trial? The judge already covered this. I'm gonna skip past this. Who here believes that it is possible for two people to be looking at the same thing and see it completely different? What's your number, man? Juror number 16. Yeah, so you know you had yes. How does it happen? Yeah. So sometimes you can be looking at the exact same thing and say, I saw this and you saw that. That car shouldn't have been there. And another person says, no, that car shouldn't have, the blue car shouldn't have been there. You say, no, it was the red car. Two people can look at the same situation and say it's different. Is there anyone that says, no, that never happens? People always see the same thing. We're all the same. Anybody feel that way? Now, of course, there are situations, right? But it is common that two people can be in the same environment and see two different things. That was your perspective, right? Does anybody disagree with that statement? Does a story told in many different versions in your mind affect the reliability of the story being told? I'm going to ask you, juror number 6. So I'm going to say that question again. Does a story told in many different versions in your mind affect the reliability of the story being told? Yeah, if it's in your mind and you are retelling a story and it's a bunch of different versions, yeah. Okay, so juror number 6 says if a witness says something multiple different ways, it kind of affects it a little bit. It kind of bothers me. Who agrees with juror number 6? Reliability is in calling the question if it's changed. 1 all the way through 5. Juror number 7, 8 and 9, 11 through 14, 16, through 20, 22 through 29, 30 and 31, 33 through 36, 37 through 40, 42 and 43, 45 through 48, 49 through 50, 51 through 53, 55 through 62, 64, 65 through 68, 69 through 72, 73 to 74. Okay, so what is the law on self-defense in Texas? What's your name in the pink shirt, sir?
Isaac.
Isaac, what's the law on self-defense in Texas? Quick, go. Okay, it's a different situation. Okay, so self-defense matters.
Yes.
Okay, it can change things
Yes.
when you're talking about an assault. Okay, so the law of self-defense specifically has different elements, different parts of it. And one of them is imminence, another one is reasonableness, the other is proportionality, and the other is that it has to be lawful. Okay, I'm gonna explain all those to you. But looking at those elements, does that seem like those might be reasonable? Might make sense why those are part of it?
Yes.
Okay, so I'm going to explain to everyone the elements of self-defense, and then at the end, I want to ask y'all, one, if you understand, and then two, if you agree with it. Okay, so listen quick carefully. So when you use self-defense, you must have the threat of unlawful force coming against you, and it must be imminent. Okay, it must be coming. It must be now, not like somebody's running 300 feet away. Eventually, they're going to get you, so you can, throw a rock there. That's the imminent. You're about to get to. Okay, there has to be some reasonable threat that is imminent. Your response has to be reasonable in the moment, right? If I see you stretch your head, oh my gosh, you're going to throw something, you're going to throw a stapler. That's not reasonable, right? It has to be reasonable in the moment, considering the situation. It has to be proportional, right? So the common way they say this: someone brings a fist, you bring a fist. Someone brings a knife, you bring a knife. Someone brings a gun, you bring a gun. That type of proportionality. And that's a judgment factor. These are all factors that have to be determined. And the last thing is, it has to be lawful. Okay, you can't be trying to rob somebody's house and then all of a sudden you say, "Oh, I was self-defense." Right now, you've heard crazy stories in the media where it's like, "What the heck?" But that's not really how it works. Right? In Texas, those are the elements. Does everyone understand what I just said about self-defense? Yeah. Does anybody disagree with what I just said about self-defense? Does anybody have a problem with the fact that we have self-defense law in Texas? Okay, thank you so much. So, is there a legal duty to retreat in Texas? What does that mean, juror number 18? Duty to retreat. You have any idea what that means?
Do I have? This might come in. Not tree.
Yeah. Do you think there is?
I think it's Moody.
Yeah, in Texas. The law of Texas. Someone's coming at you.
I'm not stand my ground.
You can stand your ground. Yeah. Does everyone agree that you're allowed to stand your ground in Texas? If somebody's coming at you. Does anybody disagree with that? Juror number 75, you don't think that's the law? Do you think you should retreat? Who else? 46? You think you should retreat, or you don't think it's the law?
No, I agree that, say it's why, but I think it's possible you should.
It's possible, and nobody's not saying that it's not possible. I'm saying legally, are you required to? Oh, I don't know what hit. Okay, sorry about that. And that's correct. There is not a legal duty to retreat. Okay, so you do not have to leave if you are lawfully present somewhere and somebody threatens you. Okay, so is anyone not going to be in the right place this week to be a juror because of personal reasons? We've already talked about this. So I'm not going to go into those and pass on that. These are the elements. They've already talked about these in detail with you, but I'm going to hit one more point. On a specified date in Bexar County, Texas, Randy Gallegos, my client, would have to be proven to have intentionally, knowingly, or recklessly caused serious bodily injury to another person. So my question is, what does it mean to cause something? Juror number, is it 8, 9? What's your number? 9. Juror number 9. What does it mean to cause something? Yeah. Yeah. And it's your intention to cause it? Yeah. Yeah. So right now, if I go open this door right here, right? I'm gonna cause it to open, right? Oh my God, I'm sorry. If I hit somebody, right? And that person falls down and they're hurt, does it mean I
I caused them to get hurt?
Yes, and you caused them because you opened the door.
Yeah.
So if this.
Then the question is, yeah, is it intentional? Is it reckless? Or is it known? Did I know that person was there? How forcefully did I open it? Right, maybe the way I just opened it was too forceful. Maybe it should be different. But all those things matter in the causation. It's not just a simple, it this happened or it didn't. It's does the causation match the situation? Does everyone understand that causation is actually an important element that has to be proven in a case like this? Does everyone agree that the state of Texas has the burden to prove causation here? Is there anyone that says, no, they do not have to prove causation? I know it's an element, but I don't think they need to prove it. Number 40, you flip it, I'll flip it, 41.
To me, I think,
All right, if y'all can stand when you speak.
oh, I'm sorry. To me, things are less causal, more superficial.
Okay, thank you so much. So is there anyone that disagrees that it is a responsibility of the state to prove causation? Does anyone disagree with that statement? Does everyone understand that it's one of the elements, parts of an element they have to prove? Okay, very good. So in a situation where assault happens, what's your number in the green blazer mail? Juror number 12. In a situation where assault happens, a lot of times there are other things going on, right? It's not just you bumped into somebody at HEB and all of a sudden you break into a brawl in the aisle, right? That does happen, but not often, right? Normally there's some other things going on. And those motivations, those other factors, do you think that they play a large part in why a case like this might come to be in court? You think it may play a large part in why a case even started to begin with? So does everyone agree that in an assault case, it's likely that the background information of why this happened is very important to understand the roles of the parties? Does anyone think the role of a party in an assault is not relevant or not important? Anyone feel that way? Say it again. Does anyone think the role, their role in the assault, in the case, is not important or not relevant? Everyone agree with me? It's important and relevant. What's doing, why they're there, what's going on? Okay, excellent. Okay, so what is the role of a security officer, a security member at a bar or restaurant? Juror number, what's your number, sir? Number 11? What's the role of a security officer at a bar or restaurant? Yeah. Yeah. When they're working, right? And what if they're not working and they decide to take on the role?
Often needs to just enjoy themselves for the night. I feel he has some of
So security has a kind of a set role in that type of environment, in a bar or restaurant situation. Okay. And what about, oh, skipped. What about a manager? A manager at a bar or restaurant. What kind of role did they have? And you think about it.
manager on duty,
Yeah, manager on duty at a restaurant.
oversees everything. At a bar or restaurant to make sure that the restaurants, nobody's behind the tables, waiters, just has multiple elements.
And commonly is the manager going to be the security as well, or normally different people?
He's gonna put on whatever hat he has to.
Let me ask you a different question. If there is a manager and a security guard, does the manager normally do the security guard's job? No, they don't. Why?
Managers can oversee everything. Doesn't go.
Yeah.
That's security. Yeah, you go somewhere, okay, manager puts on security hats. Take what they think that's like that.
Yeah. Okay. So did everyone hear juror number 11, what he was saying? Does everyone kind of understand the roles there? Does it make sense that different people play different roles in a business environment? Does anyone disagree and say, no, that's not my experience? Now, I understand there's small restaurants, smaller businesses, but I'm saying in the situation that there's a security guard and a manager, do they serve different roles? They would agree that they serve different roles. Juror number 44, which next thing? Okay, so he was saying basically that a security guard and a manager, in a situation where they both exist, both people are separate people, they serve different roles in a bar and restaurant environment. Does that make sense to you? Okay.
10 minutes.
Thank you, Your Honor.
what are some reasons that someone might not testify? Juror number 10. Kind of like you just got put on the spot. I mean, it's nerve-wracking, right? They won't want to, but also they might not want to talk to trained attorneys, right? Who have a lot to say and a lot to point at and bother them with. It might be a lot, but also not legally required to under the Fifth Amendment. Does that make sense? That in the Fifth Amendment, they don't have a right to self-incriminate. But also they may just be very nervous, right? Can you imagine being charged with a crime that has a punishment range of 2 to 20 years, and you're supposed to go get in front of a group of strangers and speak about it, and you don't feel like you've done anything wrong? That might be really hard to muster the courage to do, right? Is anyone that says, I don't care about the Fifth Amendment, I don't care about the right against not self-incriminating yourself, I want to hear from the person, and if I don't hear from the person, I'm more likely than not to find them guilty? Who says that? I need to hear from them. Otherwise, I'm not going to acquit. Juror number 36 feels that way. Is there anybody else that says, if I don't hear from the person, I'm going to struggle to render a not guilty verdict? If I don't hear the words from his mouth, even if I hear enough evidence to acquit him, I'm still, if I don't hear from him, I'm going to struggle to acquit him. Juror number 41, juror number 24 wants to hear. Everyone else understands that if you don't hear from him, but they did not meet their burden, they did not prove their case beyond a reasonable doubt, that is not enough to find guilty. Does everyone else understand that? Raise your cards on that one. You understand what I'm saying? Yeah. Very good. Thank you so much. Okay. So beyond a reasonable doubt is not able to be defined. I'm going to run through this quickly. There's no legal definition. Reasonable suspicion, you get pulled over for not putting on your blinker, right? That's reasonable suspicion to stop you. And an officer says, guess what? I have probable cause to give you a ticket. Also, now that I'm looking in your car, I see you got a beer. So probable cause to give you an open citation. And I see your eyes are red. You just listened to so many jury selection questions and you're pissed off. And now I'm going to arrest you for DWI. That's probable cause. Okay. But before you can be convicted, there has to be more things that can happen. There's another step. This is not for criminal. This is for civil cases. This is preponderance of evidence. A little bit more likely than not. This is the standard that Thomas J. Henry uses to make all of his money. It's a little bit more likely than not that this is why this person is hurt. Clear and convincing evidence is the standard that is used to take away your children. Who has children? Raise your cards. Juror number 13. How much evidence am I going to need, or is the state of Texas going to need to take away your kids? A lot, right? A lot. That is still below the beyond a reasonable doubt standard. It needs to be more than clear and convincing. It needs to be beyond a reasonable doubt. Okay, that's the next step. So for the purposes, I moved this. For the purposes of this demonstration, I'm going to skip ahead real quick and I'll come back. I say, before you get to the end, before you get to beyond reasonable doubt, there is a brick wall. This is a demonstrative for purposes of demonstration. I say that these bricks need to be removed. Okay, who is the one who spoke? It was juror number 72, right? Yes. Yeah, you spoke about the elephant, right? So what do you see in this picture?
Looks like part of the forest.
Yeah, it looks like part of the forest, right? And is that a canvas?
Brick wall?
Yeah, behind the brick wall, the forest.
Oh.
Canvas?
Good question.
Is it a TV?
I'm not sure.
Is it a window?
Photo? I'm not sure.
Yeah, so you don't know, you don't have enough from that picture to determine beyond a reasonable doubt what that is.
Correct.
Right? So just because you have a picture of an elephant with a couple pieces missing, or you have a picture of a forest with a couple bricks missing, that's not beyond a reasonable doubt. Beyond a reasonable doubt is something that you understand and see clearly all the elements are met. Does everyone understand that the state has to prove all of their elements, every single element beyond a reasonable doubt, and the picture has to be clear enough that you can convict this man and he becomes a felon for the rest of his life, and then you sentence him for 2 to 20 years in prison or probation. Okay, that is the standard that they have to meet with their case. It has to be that clear. Does everyone understand that standard of beyond reasonable doubt? Is anybody confused about that standard? Thank you so much. Best class I've had in a long time. Okay. So punishment range is 2 to 20 years in prison, or probation up to 10 years, between 2 and 10 years. Is there anyone that has a problem with that punishment range and rendering that type of punishment? Juror number 41. Everyone else, 73. Everyone else can consider the full range of punishment and rendering their punishment verdict. The jury will be determining punishment in this case. So if he is found guilty, which we are hopeful that he will not be, but if he is found guilty, at the end you will determine what is the fair punishment to be assessed. Who here believes that an aggravated assault causing serious bodily injury conviction could change your life permanently? Juror number 7, right? Do you think he would? Yeah. Does anybody disagree with juror number 7 that it would change your life forever? Who here says, well, my Uncle Ted, man, he's kind of cool. He figures some things out. He's got a lot of convictions, but he opened up his own business and he does okay. No, right? It changes your life forever. This type of conviction will change your life in every way forever. That is how important your job is. Okay, it's not small. So, I'm running out of time, and I got a couple quick more questions, and we're gonna be done here. Okay? Does anyone believe here, or sorry, does anyone here feel that you do not have the right to defend yourself in public? So that question is written wrong. But I'm asking, does anyone here feel that you do not have the right to defend yourself in public? Does anyone say that's the law? You want to feel that's the way it should be? Okay. Good. Okay. I'm going to ask scale question number 3. Is it appropriate to charge an individual with assault if someone else caused the physical injuries? And then you're going to give me an answer of what your number is. If you're a 1, a 2, a 3, a 4, or a 5. So is it appropriate to charge an individual with assault if someone else caused the physical injuries? 1, I strongly believe this is appropriate. I think this should happen. Who are my 1s? Raise them up. Okay, who are my 2s? I believe that this is appropriate. Okay. Who are my 3s? I do not have an opinion. Okay, I do not have an opinion. Juror number 3 and 4. Juror number 9 through 11. Juror number 7. Juror number 15. Juror number 41, 44, 63, and 65. Juror number 4. I'm sorry. Scale question 4. Answer 4. I disagree that this is appropriate. Disagree. 1 and 2. 5 and 6. 8. 12 and 13, 16, 19 through 21, 23 and 24, 28 and 29, 34 through 36, 37 through 40, 42 and 43, 47 through 50, 51 through 53, 55 and 56, 58 through 62, 64, 66, 69 through 72, and 74. Who are my 5s? I strongly disagree that this is appropriate. Juror number 17, juror number 22, juror number 25 and 56, juror number 30 and 31, juror number 46, 54, 57, 73, and 75. Okay. No. Okay. Scale question 6. Scale question 6. Who here would expect someone to feel intimidated if a person was outnumbered in a fight? Who here would expect someone to feel intimidated if a person was outnumbered in a fight? Who are my 1s? I strongly agree someone would feel intimidated. Okay, that's 1 through 3, 5 through 7, 8 and 9, 12 through 14, 17, 19 and 20, 22 and 23, 25 through 29, 30 through 36, 37 through 43, 44. 47 through 50, 51 through 54, 57 through 59, 61 through 64, 65 through 68, 69 through 72, 73 through 75. Who are my 2s? I believe a person would be intimidated, but not strongly. 4, 11, 16, 24, 46, 56. 3, I do not know if someone would be intimidated. I do not know 15, 21, 55 and 60. 4, I don't think someone would be intimidated if they're outnumbered. No 4s. And a 5, I definitely don't think someone would be intimidated. Okay.
40 seconds.
Thank you, Your Honor. Everyone understands that it's the prosecution's job to prove their case beyond a reasonable doubt. We have to put on 0 evidence, right? But because how serious this case is, I am going to be challenging this evidence and the case throughout the entire time. I will be cross-examining, and I may be aggressive, okay? Does everyone understand that if anyone you loved was in that chair, that you would want that attorney to do their very best and be aggressive? And please do not hold it against my client
if I or Ms. Hawkins is aggressive in trying to do her job. Okay, does everyone understand this is just my job? It has no bearing on the weight of evidence. If you don't like my style, you don't like my tone, I'm just trying to do my job. Okay, and I am a little bit intense, and I do drink a lot of caffeine now, you're young kids, just like.
All right.
Okay, thank you so much, those of you that get upgraded to the expensive seats over here and not the hard bench. I look forward to working with all of you, thank you for your time and attention.
All right, ladies and gentlemen, I'm gonna have you all wait outside. Please take your personal items with you. Please leave the cards behind. You are not excused from the courthouse, and we will call you back in. Just leave your numbered cards on the seat.
It's nothing special.
So you say things are going well, you fix it. And then people start speaking real fast. Real fast.